Today, 5 charges against Mr. Edubohin, his wife Angela Ajay-Boateng, one Mildred Donko, a former employee of UMB Bank, who resigned just in time to join in the criminal enterprise, and a company called Advantage Solutions Limited, a holding company owned by Mr. Edubohin and his wife, which received a substantial portion of the funds and was used as a conduit for funneling the funds into other companies owned by them. These other companies are Vertex Properties Limited, Vertex Solutions, and of course, the famous BMC Communications Bureau Limited, which was, if you remember, that was a vehicle that was used to steal the 49,100,000 Ghana cedis from the national security accounts. Based on the evidence on the docket, we have charged Mr. Edubohin with stealing, 3 counts of stealing, 1 count of defrauding by false pretenses, another count of willfully causing financial loss to the state, another count of using public office for profit and money laundering. His wife, Angela Ajay-Boateng, has been charged with conspiracy to steal, collaboration to commit the crime of using public office for private benefit or profit, conspiracy to commit money laundering and money laundering. In the case of Mildred Donko, we have charged her with 2 counts of conspiracy to commit money laundering and money laundering. The same goes for the company known as Advantage Solutions. Ladies and gentlemen of the press, my fellow countrymen and women, I am keenly aware of the criticisms that were leveled against me after my March 2025 press conference. In particular, some of our compatriots accused me of judging Mr. Edubohin and his dear wife prior to filing charges, and others opined that what I said of them should have been left to the courts to decide. I respectfully disagree for a number of reasons. The first is that I said nothing at that press conference that suggested even remotely that their guilt had been predetermined. Far from that. As the Attorney General of this Republic, I am the first to acknowledge that no matter how watertight the evidence of a prosecutor is, the accused is still entitled to be presumed innocent until proven guilty. That is a principle enshrined in Article 19 of our Constitution. And I cannot go against that cardinal principle. The second reason why I disagree with those of my fellow countrymen and women who think that the matters are dealt with at these press conferences should be left to the courts is that the constitutions require that we act, at least in public office, with probity and accountability. I see these press briefings, including the one I'm having today, as a way of breathing life into those cardinal values of our Constitution. Lastly, I think that there is absolutely nothing wrong with a prosecutor exhibiting confidence in his case. With particular reference to the case under review, the diligent investigations by the Economic and Organized Crimes Office led by Mr. Raymond Archer gives me a high level of hope and confidence that, all things being equal, I will obtain convictions on most, if not all, of the charges that I have preferred today. Besides the documentary evidence involving bank statements, deposit slips, check numbers, and so on and so forth, we have persons with deep knowledge of the matter who have agreed to testify at the trial. Persons with very deep knowledge, primary persons who were close to the action, have agreed, after having been, interrogated, about what they know, they have agreed to testify in this matter. Ladies and gentlemen of the media, my fellow countrymen and women, between March 2025, when I announced the arrest and detention of Ms. Edubohin, and his accomplices. And now, there has been some speculation as to whether my press conference was it another piece of political propaganda. This criminal enterprise involved the purported provision of secured internet services to Ghana Water Company Limited by the erstwhile Bureau of National Communications, now National Signals Bureau, National Signals Bureau. The contract document showed that Ghana Water was to pay BNC, that is the national BNC, the sum of 650,000 Ghana cedis every 2 weeks for secured internet services from BNC, that is the Bureau of National Communications. However, for purposes of the payment, Kobina Idubuahin provided the account details of his company, BNC Communications Bureau Limited, to Ghana Water, which religiously paid for the internet services. In other words, every 2 weeks when 650,000 Ghana cedis of money from Ghana Water left the bank accounts of Ghana Water, instead of going to the National Signals Bureau account, it went to the account of a company known as Bureau of National Communications, owned by Kobina Idubuahin and his wife. Okay? And then they did what they wanted to do with the money. We have made a decision to charge Mr. Kobina Idubuahin and other accomplices in the Ghana Water scandal separately. Okay, so in a few weeks, we'll be filing separate charges against him. And the amount of money in the Ghana Water scandal is in excess of 62 million Ghana cedis. 62 million Ghana cedis. That Ghana Water, that sometimes does not have money to pay for chemicals to purify your water, had to part with, purportedly for the provision of secured internet services by a government agency. That is what happened. And so, because the contract documents stipulated that the payments be made to Bureau of National Communications, Ghana Water then demanded that the check payments be made to National Signals Bureau because of the change in the corporate identity of BNC. What then happened was that any time the check was made out to National Signals Bureau and it landed in the accounts of National Signals Bureau, Kobina Idubuahin, as Director of National Signals Bureau, would then immediately write a check to himself and transfer the money. From our investigations, you can see the movement of the money. Immediately it comes from Ghana Water, he signs a check and transfers the money into the, his personal company account. Now, today something happened in court. Counsel for the defense told the judge that whatever I had said was a figment of my own imagination. But of course, he is entitled to earn his fee. So he can say that.
Oh, that is the latest of Kobina Idubuahin that the Attorney General put out this week during that press conference to update all of us about the ongoing investigation into some cases that he is on. It's not just Kobina Idubuahin, the latest with the Ghana Water Company Limited. In fact, already questions are being asked. The Attorney General intends to prefer separate charges on this particular one. But yesterday, Kobina Idubuahin, was remanded into the Ioko custody for the next 7 working days. His lawyer, Samuel Atachiam, doesn't want to have any of that, will tell you exactly what the coming days will look like. But that's not the only case the Attorney General talked about. Talks about an update on the Sky Train, which he says is going to prefer charges against some 2 persons by next week, or the week we are entering into. The National Service Ghost Name Scandal, he gave an update on that. And then also, as we are seeing things play out right now, we will stay the steam on this here on the key point. The Ghana Bar Association is also demanding the immediate revocation of the suspension of the Chief Justice, Geto Tokono, describing that action as unconstitutional, lacking any legal basis under the 1992 Constitution of the Republic of Ghana. This statement by the GBA has generated backlash, a lot of reaction. We're getting to. That's a real departure from the previous stance that they took. Well, we'll tell you exactly the detail of that resolution that they reached after the bar conference just about a week ago here in Accra. So stay with us. They are calling on the president to release the full decision establishing the case against the Chief Justice. Reason why she was suspended in the first place. Well, is that also grounded in law and in fact, or it should be after the fact, as the likes of Professor H. Kwesi Prempeh have proposed? We'll get into this matter this morning. The president has also put forward 7 Court of Appeal justices for potential elevation to Ghana's Supreme Court bench. These nominees are expected to be considered by the Judicial Council and subsequently vetted and approved by Parliament. That has also had its fair share of conversation this week. We'll get into why this is an issue and what exactly will this process of approving these persons for 4 of them be. I mean, the 7 who have been nominated be. We will get into it this morning here on Key Point. We're back shortly after this quick break. My guests already seated. We'll get into the matters this morning here on the Key Point. As always, you are an integral part of the program, so let's hear from you. We're live on 3FM 92.7 on a number of radio stations across the country, and then on the Voice of London radio in the heart of the city of London as well, for the people who are out there following the issues back home. We will be back shortly after this quick break. My name is Alfred Okanse. Welcome.
I have today filed charges against Mr. Dubois, his wife Angela Adeboting, one Mildred Donko, a former employee of UMB Bank, who resigned just in time to join in the criminal enterprise, and a company called Advantage Solutions Limited, a holding company owned by Mr. Dubois and his wife, which received a substantial portion of the funds and was used as a conduit for funneling the funds into other companies owned by them. These other companies are Vertex Properties Limited, Vertex Solutions, and of course, the famous BMC Communications Bureau Limited, which was, if you remember, that was a vehicle that was used to steal the 49,100,000 Ghana cedis from the national security accounts. Based on the evidence on the docket, we have charged Mr. Dubois with stealing, 3 counts of stealing, 1 count of defrauding by false pretenses, another count of willfully causing financial loss to the state, another count of using public office for profit and money laundering. His wife, Angela Adeboting, has been charged with conspiracy to steal, collaboration to commit the crime of using public office for private benefit or profit, conspiracy to commit money laundering and money laundering. In the case of Mildred Donko, we have charged her.
Well, so that's the Attorney General this week, given an update on this particular case. And you heard the charges that he read against these 4 persons. There are 3 living individuals breathing with blood flowing in them, and an artificial individual, in this case, the company of Advantage Solutions that was owned by Kwabena Dubois and his wife. So these are the accused persons. As we do know now, if you recall, just about a little over a week ago, Kwabena Dubois and his wife sued the Attorney General for defamation because he said he had addressed press conference, said a number of things about them, accused them without any basis, and all the while they had not been charged. Well, this week, this is what the Attorney General has done. We're going to put that on the screen right now. 3 counts of stealing, contrary to Section 1241 of the Criminal Offences Act 1960, Act 29. 1 count of conspiracy to steal, contrary to Section 23 and 124 of the Criminal Offences Act. 1 count of defrauding by false pretenses, contrary to Section 131 of the Criminal Offences Act. 1 count of willfully causing financial loss to the state, contrary to Section 179. And then, in fact, he alone, Kwabena Dubois, has 8 separate counts on him. Another, using public office for profit, contrary to Section 179CA of the Criminal Offences Act. 1 count of obtaining public property by false statements, contrary to Section 5 of the Public Property Act 1977, SMC Decree 140. 1 count of money laundering, contrary to Section 12 of the Anti-Money Laundering Act. 1 count of conspiracy to commit money laundering, contrary to Section 3 of the Anti-Money Laundering Act. All of these, you heard the Attorney General say that in court, Samuel Atachia said some of these charges just a figment of the Attorney General's own imagination. The AG wouldn't have any of that. He says he has a watertight case against these persons. He's not alone in this. As we do know, his wife also slapped with 4 counts. 1 count of conspiracy to steal, contrary to Section 23, 124, Criminal Offences Act. 1 count of money laundering, contrary to Section 1, Anti-Money Laundering Act. 1 count of collaboration to commit a crime, to wit, using public office for profit. 1 count of conspiracy to commit money laundering, contrary to Section 3. And then Mildred Donko, who's only been described as a banker, who a long time ago, not recently, from what we also got to know, he resigned quite a while ago to join and work for Kwabena Dubois and his wife. But she was a banker. This is it. 1 count of money laundering, contrary to Section 1, the Money Laundering, Anti-Money Laundering Act, 1 count of conspiracy to commit money laundering, and then this Advantage Solutions Limited, in law, this company is identified as a person, an artificial person who can sue and be sued. So Advantage Solutions Limited has been sued as well, and part of this. This is the 4th person. 1 count of money laundering, contrary to Section 1 of the Anti-Money Laundering Act. 1 count of conspiracy to commit money laundering, contrary to Section 3 of the Anti-Money Laundering Act. And as we see there, 2 counts. Yesterday, the 2 lawyers in this particular case, the Attorney General and then also Samuel Atachia, who is counsel for this woman, and then also Kwabena Duboahing, were in court, met the judge in chambers. Afterwards, we got to know that Kwabena Duboahing will be in the coolest of the Economic and Organized Crime Office, EOCO, for the next 7 days, because the Attorney General made a case that he could tamper with the witnesses, or he had attempted to do so. Now, Samuel Atachia wouldn't have any of that. After that particular meeting, he spoke to the press, expressing his displeasure about the latest in this case. This is what he said. Take a look.
This undermines totally what they are touting in the press, that they've gotten all the evidence against them and they should even come for plea bargaining. This is a lottery of a trial. That we should all look at it from the perspective of the razzmatazz and the theatrics. This is a very painful somersault for the Attorney General to say, I want more time. A man has been arrested 20th of March and he got bail on the 8th of April. So was the Yoko sleeping on the matter? I'm careful. Let's have a phone conversation and somebody says that, oh, I'm trying to, romance the Attorney General. There's a precedent. And I've been around for some time. I don't want to talk to the Attorney General, although we are very good friends, lest somebody might even go and interpret it. And somebody might even go and leak a tape. Atta is hobnobbing with the Attorney General so that you have some advantages. That is why I'm very quiet about it.
Describes all of this as a painful somersault by the Attorney General and how things are played out in the public domain. There's been, divergent views about whether what the Attorney General is doing and addressing the press. This is the 2nd time on these matters he's investigating is the right thing to do. But then again, welcome. We're live on 3FM 92.7, also on a number of radio stations across the country, and also on TV3 Ghana on Facebook, and on the Voice of London Radio in the heart of the city of London, and then also on 3news.com. Martin Pebo is back in person, and not virtually, joining us in the studio for a conversation today. He's a private legal practitioner and the convener of the Prosecution demonstration. Lawyer Martin Pebo, good morning. Welcome.
Yeah, morning. Thank you. It's good to be back. All right. Yeah. And good morning to our cherished listeners and viewers. This is Ghana's #1 political economic talk show, right? Yeah, so it's good. And as usual, let me do the rituals. Yeah, it's important. You see, there's a Kufu message that in the new constitution, we should hive off the role the president plays in the appointment of justices, etc. You see now the debate has come to the fore. So you see that we had been championing this at least a year before it came, right? And in matter of fact, the broader Ghanaian society, this debate for a new constitution had been on for at least a decade now. So it's good that we keep repeating. We didn't start this just because this removal or impeachment proceedings of the Chief Justice Tokonu started. No, we have been saying this for at least about 6 months before this proceedings started. So the Kufu's message is that in our new constitution, the president should not have a role in the appointment and discipline of judges. And indeed, Chief Justice Tokono said the same thing at her vetting, except that when she took office, it doesn't appear she made quite substantial efforts at having the constitution amended. At least from where I sit, I didn't see rallying the public, starting a debate on it, right? So let's greet Domahini again, Domahini, and then Togbe Afede. These are chiefs who spoke when Akufo-Addo was terrorizing us, taking us through very bad governance. A lot of people sat quiet, sat on their hands, but Togbe Afede and Domahini stood up. Yes, from time to time, Otunfo also did, okay? But I think considering the size of the, let's say their kingdoms, etc., these chiefs did more, right? And finally, Galamsey, but of course not the least. Kentucky Teku through the second. Galamsey says he wants to collect the Cecilia Dapa money. Yes. So Galamsey, good morning. Thank you.
We'll have the latest on that, I'm sure, next week and see how the week will play out on this particular Cecilia Dapa case. We're taking a keen look at how issues are unfolding. Oliver Baka Vomawo is a private legal practitioner. He is also joining us in the studio for the conversation today. It's good to have you. Good morning.
Good morning. I'm happy to be here as well. It's been a minute, so I'm looking forward to the discussions and conversations today. You know?
Indeed. And we'll have Christian Malm-Hesse. He's also a private legal practitioner. He's going to be joining us in a bit. We would have Professor Bafo Ajimendua. He is a former governance expert and advisor to the United Nations. He's also going to be joining us on the show in a bit. But sort of on this note, you heard what the Samuel Atachian said, Lawyer Martin Pebu. It's a dangerous somersault by the Attorney General in this particular case, and having his client in the coolest of the Economic and Organized Crime Office, that's Kwabena Dubois, for 7 days, as we saw yesterday. Then again, fundamental question is, what exactly was done wrong? Is it a sentiment you agree with or you share?
To be straight, it's not possible, to put it very simply, it's not possible for me to either agree or disagree with Atachian. I say so because, I wasn't there, so I didn't hear what they said in chambers. You see, it tells you that to the extent that they had to go into chambers to deal with certain parts of the case, those parts, or that part of the case is sensitive. So I wasn't with them in chambers, so I haven't heard what the Attorney General said and what he, Atachian, counted. So to the extent that we've been disabled from hearing that, it's impossible to side with him. Of course, I wear a very big hat in this part of the law when it comes to bail. I think I've done my bit when it comes to bail. At least I've taken 3 different decisions, 3 different cases to the Supreme Court, and they all went well. Of course, it's because it's the Supreme Court that's interested in expanding the frontiers of personal liberty. So you have Pebu number 1, Pebu number 2, Pebu number 4, right? Yes, different chief justices. So yes, I have a soft spot when it comes to bail generally, but it all depends on the actual facts of the case. The Attorney General made a request and the judge agreed that they should go into chambers. So only the 2 lawyers went in there. Even you, the media, you were not allowed in. So everything that was said in there is more or less like a closed book. Nobody in camera.
Yes.
And when it's in camera, how am I now going to say, oh, well, okay, let me just go with my emotions because for me 48 hours is 48 hours, etc. Then I must go with Atachian. No. So even to the extent, you see, to the extent that Atachian himself didn't even reveal what happened in chambers, then it tells you that we have to tread cautiously. You see, that's his client. He hasn't revealed what happened in the judge's office, or like we say, chambers. He hasn't revealed it. So once he hasn't revealed the specifics, it means that nobody is in a position to side with one or the other. So in such a case, you give what we call a margin of appreciation to the judge. It's the judge who heard it, and based on his judicial discretion, went on to remand the accused for 7 days. So it's not possible. It's not possible.
He says this is a travesty of justice, playing with the liberty of an individual, essentially. And that's where you gravitate towards in your earlier submission that, yes, you align, you are on record, and indeed having contributed to the legal jurisprudence in this country as having fought for bail.
Yeah.
But
different decisions over starting from 2015 to 2019. 3 separate Supreme Court decisions. People number 1, they used to jail people, right? If the accused absconded, which is wrong. I took it to court, so that was the first decision, December 2015. Then the Supreme Court said, no, we'll strike this down. Then, May 2016, the non-bailable offenses case. There were about 12 offenses. If it was slapped on you, that was it. You wouldn't get bail generally until the end of the case. So even if it took 10 years, whatever, you would stay in, right? Yes, and we saw that it was such an abuse. The Supreme Court looked at it. That's the Georgina Wood court. Yeah, Georgina Wood stood there and said, no, this thing is going down. Then, of course, people number 1, 2 were still under Georgina Wood, right? Then, Georgina Wood left. Then Sophie Kufu came in 2019. People number 4. That's the one that weekends, the police will wait. When it's Friday, then they come take the suspect or accused, knowing that Saturday, Sunday, there's no court. So that by Monday, the person would have sweated in custody, etc. So Kufu, that was her valedictory judgment, the last one, meaning very dear to her heart. That was the decision she gave and then retired from the Supreme Court, right? Said no, 48 hours is 48 hours. Come rain or shine, right? So they subsequently, just CJ Eniyebua gave directives on how to access the court during weekends, public holidays, etc. I've done about 5, 6, right? And you see even the recent elections, you see that the NDC and the NPP, you see on public holidays, they were in court. Yes, that's, consequent upon that decision, because in people number 4, then the judiciary broke free from the executive. They made it very clear that the president cannot determine for the judiciary when the court sits. So they determine Saturday, Sunday, public holidays, they will sit because it's an essential service, you see. And since then, you know, so we are growing. Of course, some lawyers, especially in the hinterlands, have to access the courts on weekends, but it takes time. They also have to get up and fight because Chief Justice Eniyebua gave the directive. So it's for you to push the registrars, right? Whether you are in Boko or Navrongo, wherever, right? So yes, all these decisions show that I'm very keen, I have a strong passion for personal liberties, right? Very strong. But like I said, that is the theory. Those are the principles. The principles have to be applied to specific cases. The Attorney General says Edubuahin is interfering. As to how he's specifically interfering, we don't have that.
Because it was in chambers.
Done in chambers. So in that case, but of course, so I mean, I can't. There's no way any lawyer, I mean, who is seized with all the facts can castigate one part and then say the other one is right. Except that, of course, so now I'm looking at it that, you see, there is this part of the law that I'll be interested in, which we have to get up and fast track. You see, the house arrest. Because when you have a better home, why wouldn't you ask for house arrest? So the one, they will even wear you an anklet. You say, so you are chained to your home. If you step out, the thing is connected, like the tracker, the ones they put in the cars. If you step out of the house, it will show that you've breached the conditions. So house arrest, I think we yes, because Edubuahin has over 30 houses at least. They state, yes, you see, a man who has over 30 houses is being kept in the Yoko cells. So that side, yes, but that's the state of the law. We don't seem that bothered. And often it's these politicians who have to be, because they are the ones who go and they have access to all of our money, but they don't pay attention to how we should reform the law. Today you have about 30 houses, but they say stay in the Yoko cells. You see that thing? Just like the way I made it earlier on, I said it earlier that when Chief Justice Tokono was being vetted, they asked him, what do you want changed in this constitution? The first thing I heard with my own ears was that the president should not have a role in the discipline of judges. CJ Tokono took over. I don't remember her calling a debate on how we should start to amend the constitution. And then 2 years on now, that very thing she said we should change is being used against her. You see that thing? So when you get a big position, you should be thinking forward. What should we do to improve? You see the situation? So let's think seriously about it. This matter of house arrest, you know, we should. It's long overdue. Because a lot of the time, even by the time you become minister, etc., on average, you would have a couple of houses. Yet, when you get trouble,
we'll put you somewhere.
Go and throw it somewhere. You know, it's like we like punishing people. And our law is very clear that we shouldn't use bail to punish an accused before the conviction of the accused. You see, we shouldn't use bail. We shouldn't use bail to do that. You remember Oliver is here. You remember how Oliver and Co were treated a few months ago. And you see how we're very strong. We didn't miss where we took on the judiciary. We called out the judges left, right, center. That no, that was wrong. You see, but these things keep happening. They keep happening. We say we will not work hard to improve the law. Our laws are so archaic. The Act 30, 1960 law. 1960 law. Act 30. Yeah, how clairvoyant could people have been in 1960 that they could have seen everything that will happen in 2025 and written it down? No. But the law is so archaic, extremely archaic. And then once in a while, you see the politicians who make efforts at amending, then it doesn't go far. Yeah, there were attempts. I remember in the past, Justice Doche was involved, etc. But you know, the Attorney General then, it disappeared. Then we did some colloquia, we did symposia, then Justice Ifya Asaribochi, you know, the Court of Appeal judge. When she sees us, she say, hey, maybe you guys are interested in amending Act 30 or not? And also Act 29, Ifya Asaribochi. She says it. Are you interested or not? So maybe with this, when the Dubois comes out, she should probably be leading the charges because he is feeling it now. Of course, and all of us here, all of us here. Oliver has suffered it, we all know. Had not been for Domahini, you see, granted Oliver bail. And when Domahini granted Oliver bail, see how they threw him off to outside Accra and all that Domahini suffered, you know.
Well, you talk about people number 1, 2, 3, and 4, and that's how much you have contributed to improving our justice delivery system in this country, and that has to be put on record. And even though you don't like, you know, being
it's the Supreme Court. It's a policy court.
It is because you took the decision, and you had to pay the cost yourself, is it not? Your own money to try and improve the jurisprudence. It's worth commending you for. Had it not been for you, maybe we will still be in those dark days of the law. But at this moment, also joining us shortly, Professor Bafwa Jimendia will join us on Zoom. As I indicated, Christian Mamhesi is a private legal practitioner. Good morning, welcome.
Good morning, and thanks for having me. Also, Godwin Eduji Tamaklo is acting CEO of the National Petroleum Authority and Director of Legal for the NDC. Good morning. Welcome.
Good morning, Alfred, and good morning to my co-panelists.
Good morning. It's good to have you.
And Senior, I can see that the ice is still on your...
It hasn't melted.
The ice is still on your skin.
Cold was killing me.
But Alfred, a quick one on what my senior said in respect of the bail issues. I think, again, like we're saying, we are a growing democracy. We want to be progressive. And I always say that falling foul of the law is just, it can sometimes just be somebody's fantasy. I mean, for people to sit down, persons of high repute, quote unquote, to sit down and to even suggest, even remotely, that this man here, this man here,
you mean Oliver Bakavomao,
has the capacity to overthrow a government. That should tell you the extent to which human beings can go if they target you. And it is for that matter that I always say that the constitutional safeguards that we always preach, it's not for our use, it's for the benefit of the collective. I remember vividly when I was counsel in the NCA matter. My learned senior here has started some advocacy and work at the court relative to disclosures in criminal matters. We took it up. I remember the day I moved the application for disclosure
before His Lordship Justice
Eric
Chebafo. When I moved the application and the Attorney General, led by Madame Gloria Kufu, opposed the application and indicated that as far as our laws are concerned, issues of disclosure relates to offenses that are done on indictment. And that as far as Act 30 is concerned, it makes no such provision for disclosures in summary trial. It was when I drew my law's attention to the fact that per Article 132, they have put a rival meaning on the constitutional provision relative to Article 19.2 C and D. It was then that my Lord agreed with me, because I had then indicated that Article 132 is mandatory, and for that matter, to that extent, he ought to refer the matter to the Supreme Court for interpretation. Graciously, and I want to thank him, he agreed and referred the matter to the Supreme Court. That eventually became the basis on which today, in criminal matters, they are allowing for disclosures. You understand?
And some good work as well.
I mean, you have to. You have to. And I remember, and you know what instigated that? Because as counsel in the matter, at cross-examination, you have brought board minutes right there in court and asked to object if you have any objection, because they are about to tender it, whether you have any objection. And I kept complaining that, my Lord, I'm seeing these minutes just now. So permit us to go and study it and come back. So I said, look, one day I just called my friend, Randolph Chumesi, and said, look, Ray, I want to do this. So I remember when I did the application, I sent it to Justice I. That, look, see, I want your, your opinion on this, your review on this application I want to do before my Lord Chebafo. So he looked at it, he said, it's excellent. Look, Uganda, in 1993, allowed disclosures in criminal matters, Uganda, under Yoweri Museveni.
Exactly.
But Ghana, with all our records, it has to take us late 2019 to allow disclosures in criminal matters. So sometimes our democracy may look advanced, but it's so superficial.
Oh, extremely. Let me put one sentence to put it in perspective for you. Like you said, I started it 2 years before I brought back. When the first time the case was called in the Supreme Court, because of the documents are taken there, to be honest, I don't mean negatively, but I have to describe for you. This simple matter of disclosure, the court, the questions, took us 2 years. Then eventually Eduji's case came. Then they said, okay, now 2 years.
A glorious opportunity. It's a life matter.
2 years.
Let's deal with it.
You go and you argue. Then they say,
based on that, we have practiced directions and all of those things on disclosures in criminal matters. And you know, sometimes when an accused person even sees the weight of evidence that the prosecution have, they themselves will say, look, I want to enter a plea or something.
And in fact,
which is all well and good, you understand. So the issue of house arrest, I strongly believe that my friend here lives in a very plush apartment.
You don't know where I live?
so for the benefit of anything, why take him to Ashama?
That's why I bring in Oliver. Because, you see, this is what Atachia says, that, quote, I don't want to eat a meal which is not cooked. I thought we should wait. And then what the Attorney General said in the press, we will never prosecute anybody unless we have all the evidence. This cancels the initial position. We don't have the evidence, but we rush the man to court and you come and plead with the court for more time. Oliver, this is the account of the Attorney General, that's the Samuel Atachia after that in-chambers meeting, which we don't know, as Lawyer Matikwebo indicated, what was discussed and reason why the judge even granted us 7 days for the Attorney General to get into the case.
You know, for me, I think that the nature of our politics is so fast that we don't often take time to reflect on the depth where we had gotten to as a country under the former regime. In the conversations around this constitution review thing, Professor Akila Kwasoya asked me a question in terms of our interventions and how we improve the constitution. Is how do we prevent another Afoko from happening again? And it's something that I wake up and think about all the time. That in terms of how our legal system is set up, what is it within the framework that allowed it to be so manipulated under the former regime? And how do we prevent the ease with which persons can be so victimized and persecuted for years, with the courts looking on, and sometimes with their blessing even? And the same context, you know, we're having these conversations, and I'm amazed by the facility and ease with which people are throwing out, you know, these seemingly progressive ideas about the constitutional regime. When we protesters, I was in custody for over 30 days on a misdemeanor offense. 30 days on a misdemeanor offense. Nothing has been heard in respect of us. In fact, Benjamin Akufu, one of our conveners, he wasn't even at the protest.
Yes.
When he was arrested because he came to see me at the hospital, he went before a judge. He was not even allowed to argue for bail. The judge says, I am reminding you, in the public interest.
That's
he went to court.
Yes,
for 17 days.
We mentioned it. We told them we are not happy with
you know?
it. Yeah.
So sometimes it's so bizarre to me, the way in which we turn around and see the ways in which our judiciary had been so instrumentalized to deny people. And we forget that these principles that we are calling hallowed principles of personal liberty have always existed and applied to everybody equally. So I am amazed when it comes to persons like this, somebody who is being accused, okay, of the extent of monies that is being accused of, compared to what we were being accused of. Just take the accusations alone at face value. And look at the differential treatment itself. For me, it's worrying that, so why can't every Ghanaian assess this level of treatment? I have a client that I'm speaking today. The offense for which he's charged is 5 years. He has spent 4 years and 8 months in custody. And bail applications have been refused 6 times for a first-time offender.
A first-time offender?
For a first-time offender. When we asked for that, even that matter to be referred to the Supreme Court, the judge refused again. And I'm like, and I keep asking, at this point, we just told the client, just plead guilty. Because you have been kept in custody for so long that even if you were sentenced, you would have spent less in prison than you have currently served. Because the Prisons Act says we divide it into 3. And so he would have already been released if he had pleaded guilty and been given the full sentence. But he's still in custody. The matter has still not been determined. So for me, I don't understand why there's this instinct of weaponizing people's personal liberty. I don't get it and I don't understand it. Now, on questions of whether or not a person is entitled to bail and whether or not they might interfere with other witnesses, it can't be speculative. And I've seen these judges say this, oh, if a person is released, the person is going to interfere with other witnesses without any basis of evidence. In this particular case, my understanding is that something was presented, and that's why they needed to go into chambers, that there was credible evidence based on surveillance that this person was interfering with witnesses.
You mean Kwabena Edubuahin?
That's Kwabena Edubuahin. That's the conversation that, again, like Senator Martin Pebu was saying, we are not privy to. But so many instances have happened where judges speculatively, there's no evidence before them that you have done anything to interfere with any witness, and on the basis of that, denying you bail. Well, now somebody is being given, even when that accusation has been made and proof has been provided, it's been remanded for only 7 days. I have never dealt with any client that has gotten a 7-day before. But we thank God that if whatever is good for Edubuahin is good for Asimesi as well. So that when matters also come, I am hoping that judges take the cue from how we treat politically exposed persons and extend that down the line and down the criminal justice value chain, so that everybody then can get access to that. So that's kind of my thinking generally about some of the things we're seeing in this conversation.
And Christian Mamhesia, I'll bring you in here, because in the end, that's what Oliver talks about the differences in the treatment depending on who is involved in this particular, or in the case, as we have seen it. Even though in the 7 days, you hear Tacha saying, but why? This administration is talking about a 24-hour, so the court can sit, on weekends and get the matter fast-tracked. But the judge thought otherwise. Could anything different have happened?
Just like my senior mentioned, it is one that we are all not privy to the evidence that was put across, because the Attorney General or the prosecution side maintained that there was some evidence that pointed to the fact that the accused had been interfering with investigations and putting together evidence and all of that. And it becomes one of the reasons why bail could be denied based on the discretion of the judge. Now, it stands to reason why the judge decided to call all parties to chambers and agree on something. That's which they agreed upon, that deliberation that went on. The public is not privy to, so it will be quite difficult to say, but we could only speculate legally and say that, yes, in a situation where it happened to Mr. A, could we pray that it happens to Mr. B, like my other senior mentioned? But the problem is that with justice delivery and depending on the court system, even though we say the High Court is one, every judge dissents differently, and that always creates a room of difficulty. The desirous situation would be that matters in this nature will be looked at dispassionately, and even though we always say the law is in the bosom of the judge, it comes with that judicial discretion. Again, that judicial discretion can also not be measured with a rod of certainty, because in exercising it, as Court A would exercise it and say, okay, if interference, let me remand you for 7 days. Court B would say, that evidence has not met a threshold for me. I am not convinced. I would dismiss that application, so that the matter will be heard. So that the matter will be heard. Or there's also the understanding that now, before you arraign somebody before the court, you should have put your evidence together so to proceed with prosecution, and that it is not midway or in the course of it, you would say that I'm still putting evidence together so to prosecute this particular person, and that you have the firm belief that there is an interference by that particular person or by the accused person, and for that matter, certain number of days should be given to you. Now, it stands to chance to reason that if those number of days are given you, would your investigations be over by then for prosecution to proceed with all that is required of? No. So it is another area that I also believe that Attorney General having continuous legal education with the delegated prosecutorial team should look at, especially with the police, because we all go through, fighting for our clients and that harrowing experience that no lawyer would want to see his or her clients go through. Yes, sometimes you argue out so passionately about your legal points, but you are left with little to do than none. And because the law is in the bosom of the judge, you are left with that.
But you took issue with the Attorney General's continuous address of the press and the nation on these cases he's prosecuting. The AG thinks otherwise. In fact, he defended that particular decision again at this press conference, indicating that in his view, to the extent that probity and accountability are two of the many principles that this constitution is pinned on, he believes that what he's doing is right, and he hasn't made any prejudicial statement for that matter. And so he's going to continue, much to what you say may not be right on his part in addressing the press on these matters of the law that or the cases that he's investigating. Why is that?
Yes. Senior, I think you did a matter on innocence and Article 19. Proving somebody guilty.
Yeah, that's the non-bailable. That's what the spoke of based on, to say all offenses are bailable.
I would draw authority from that particular Supreme Court decision. You see, when you ply your case in public before any judicial pronouncement is made, you put the suspect, now accused, you put that person in the mind of the people as cloaked in guilty. Now, the tendency of it is, before that person is held through the criminal system, that person has already been hanged in public. So should it go through such that Attorney General loses the case, what becomes of it? You now give right to the other person to fight for the reputation that you have bruised so much. So yes, I believe in probity and accountability, but I don't believe that the pendulum should swing this way such that it would touch on the reputation of the person. Yes, it is cool that arrests would be made. Yes, these are the arrests, these are the charges preferred against them. That is fine because that is factual. But to run commentary and to continuously give briefings about this, there's a fine line of doing that, and also the propensity of swinging into damaging the reputation or sinning against Article 19 to brush in the eyes of the populace that this person is guilty and we hang him as that, even before the matter is held in the court of competent jurisdiction.
I think
that's what I'm coming to you.
To put matters in proper perspective, you see, you have a situation where a political party makes a campaign pledge that I intend to fight corruption. And it was a major matter relative to its overall campaign, right? Mm-hmm. Then you also have a situation where the party says, I will do oral. Mm-hmm. Now, there are people who voted for the NDC, possibly not because they want bread and butter, but they felt that there was some level of unbridled corruption or whatever. And so that's all they wanted for change. That's a constituency you must also satisfy as a government. You will note that the Attorney General has been very cautious. After filing the charges, the comments have been very, very, you can see caution. But when he first addressed the press and revealed the extent of the investigation, it was nothing sub judice. Because at that time, he had not filed criminal charges against anybody that you can say that you will be in the realms of prejudice or anything. He is saying that as the chief law enforcement officer and the principal legal advisor of government, the investigators I have marshaled. This is what they are telling me by way of their investigation. And that the details look cold. The details look terrible. At that point, he is permitted by law to address the people. And I remember, my clients, when they were being prosecuted, Nanado went to the bar conference in Takrade. You remember the bar conference that happened in Takrade? And among, according to him, his efforts are fighting corruption. He listed Opuni and Thompson. This. He went through one after the other. I recall vividly. Godfrey Yegbo-Adame went to London, a public forum, and brutally attacked Opuni and Seydou Agongo in the name that he was fighting corruption by way of prosecution. I have actually heard leading members of the NPP say that, oh, John Mahama and his NDC, no mujamo omenum. They were bragging. They can't do FOCO. So if the Attorney General comes and say, look, contrary to the claim that we can't do FOCO, this is FOCO.
Well, the concern is that the court of public opinion will form an opinion based on what the AG says.
First of all,
how much of
justice
that plays a role
from who?
In the people.
Justice emanates from who?
The people.
Remember, no, hold on. Remember that we're supposed to be back to the Leviathan. the state of nature, where it is mob justice, might is right. However, at least we go back to the Hobbesian, issues. However, we have all resolved that instead of us meting out justice to people, why not us allow a group called the judiciary to perform that role? Ordinarily, we were supposed to be administering that justice. So the Constitution itself recognizes, it said justice emanates from the people. The people must know. And that is why in advanced countries, even for criminal district, you still have your peers, by way of a jury or whatever, having a say.
How do you respond to those who say that no matter how watertight your case is, whoever is involved is innocent until proven guilty?
I have been an advocate. Look, for the past 8 years or 11 years of my law practice, I've actually been doing criminal defense, like my senior here. I've never worked for government or prosecution. I've all done criminal defense all my life. I've gotten people acquitted and what have you. So I am someone that I don't joke with that hallowed principle, the presumption of innocence, that the Constitution and its framers gave that constitutional endorsement to. So I am the last person to say you are guilty. No. But a prosecutor doesn't go to court to say the person I'm prosecuting is not guilty. That's the reason why you are in court. So you notice that even in the US, the advanced countries, when state attorneys go to court and they will address the press and say, this is the case we have put before the judge. And with the evidence that we have, we strongly believe that we can secure conviction. At the point that we should be clear that it is not persecution, but what? Prosecution.
Let me jump in a bit here, because on this point, I mean, I think that one of the things that we need to be able to credit the Ghanaian public with is that they have an interest and intelligence enough to be able to understand processes that are happening generally in the country. I believe strongly, irrespective of an accused person's right to innocence, that the public have an interest to be updated in the steps that the state is taking to deal with corruption in particular. And I believe any cases or any documents that are filed in courts are matters of public, are in the public domain anyway, that the Attorney General is entitled to, on their website, provide us a list and updates of the cases they have filed and the stage at which those cases are. The big question about the innocence of accused persons is whether, in terms of the trial, there's process integrity. Whether you can go to court and that nothing within the courtroom would be obstructed or constructed in a way that presumes or takes your guilt for granted. That exists. I think it still exists. So, but the updates to the public, I think, are necessary for the health of our democracy. If anybody, or if this democratic project will lose its balance, is that the people who have come to assume and understand that no matter how much corruption public officials get into and involved in, nothing happens to them. We must know how to carry the people along for them to believe that the state is interested in going after and prosecuting corrupt offenses. So for me, I love and absolutely encourage the Attorney General to continue to give the public these kinds of updates. We ourselves are entitled to we are entitled to be able to interrogate them. And in the same way, I must say, if this government was then in power and the next government came in, and public officials were said to have been involved in corrupt deals, I would want the next Attorney General as well to update us on what steps they are taking to prosecute them as well. So I am consistently pushing Attorney General to be absolutely ruthless in going after any individual who has been involved in corrupt cases. Well, and I believe that in terms of how ORA is constructed, that there has to be a website where we can all go and look. These are the number of cases that have been prosecuted. These are the number of public officials. This is the stage at which the cases are. That at least, as long as it does not detract from the fact that when a person shows up for trial, the person will then have the benefit of a fair proceedings, then that's fine. I see, but you see, you acknowledge... If you listen to my learned senior Atachia, just to clarify, if you listen to my learned senior Atachia, he created the impression as though the AG went to court without evidence. I think it's erroneous. What happened is that when an accused person
maybe during the investigation, is granted bail, one of the conditions of the bail, and in fact the lawyers in advocating for bail, usually what we say is that our client is not in position to tamper with witnesses or the evidence. And so for that matter, the court should admit the person to bail. Gracious. Now, what the AG is saying is that in this specific case, having been granted bail by the court, the accused person has taken steps, which steps, if permitted to allow or to proceed, would have the unintended consequence of influencing witness. The person can go to and say, Minya, court now, you understand? You are basically influencing the witness. You remember the Jakpa Attorney General conversation? Exactly. Because at this point, where, for instance, charges have already been filed, and you are calling a witness that help me make my case sweeter, that is witness tampering.
See, and that's what Atacha said. He's not even going to call the AG at all. He will not have any phone call conversation because of this precedent. The AG raised concerns
so
about
I think we need to clarify.
But you acknowledge the slippery path that the AG might be on, to the extent that, yes, these public or continuous press conferences would update the public, but then again, the public would also form an opinion because the public court of opinion will be at play. But then you would have to also prove beyond reasonable doubt that what he has said in these press conferences hold in court. Because proving guilt in criminal cases, it's not a walk in the park. You know this, and this is not for me to say. So that is where the concern is to that extent.
Yes, listen. There are two things that happens when the AG addresses the public. That what he's saying is that this is the evidence we have gathered so far and that we are taking to court. It allows the public then to be able to form an opinion or dispel a notion whether or not these prosecutions are politically motivated or not. We must remember that it is oftentimes, in terms of the level of corruption we're talking about, it's usually politically exposed persons. Persons with significant power and resources in terms of media, in terms of how they form and move public opinion. And so we are interested in knowing that the Attorney General is not going into court on frivolous grounds alone. That the public is entitled to know. Now, if the Attorney General, while the prosecution is going on, after every day in court comes to the public and says that this is the questions I asked, this is how he responded, things like that, I don't think it's proper. But as to whether or not, at the point decision is made to charge a person with a crime, this is why we have arrested this person, these are the basis of the evidence on which we are going to court, the person will be entitled to their defense. Nobody has ever assumed that once an Attorney General presents a matter to the public, then it's done deal. Everybody understands that it will be tested in the courtroom. Again, I say that we cannot create a society whereby we think that technicality of the legal and criminal proceedings and criminal justice system must be removed from the public. They must be carried along through a process of public education. And that process of education tells that when Attorney General says, okay, we have done rigorous investigative work. This is the evidence we have gathered. Our task now is to go to court and prove their guilt beyond reasonable doubt. An accused person is entitled then to be able to poke holes in our case. But our job is one of diligence. And our job, like he's consistently said, which I agree with, that I am not going to court unless I have gathered the evidence that leads me to believe that I'll secure conviction. I think that is important. Now, particularly in this last point, particularly in our jurisdiction, whereby the vast majority of cases that we try are done before a judge and not by a jury, where you say that there's possibility of jury contamination, then the risk is even lower than we think it is. That's why I'm saying that whether or not in terms of the criminal trial itself, is there process integrity? If there's process integrity, an update to the people in a democracy, as it happens in so many other democracies, is nothing that will create alarm bells. And in fact, there's nothing that he has said so far in any of the press conferences that I'm like, okay, this is treading beyond where you should be going.
But is there process integrity? That question you asked.
There's nothing that they have said so far, even in terms of the accused persons, said that they have gone to court and they have been denied certain rights. Indeed. In fact, the conversation we have been having around process integrity is these conversations around disclosures, which our laws did not allow. Now, if anything within our law do not allow them to be able to assess a fair trial, they have the right to be able to push those as well.
Okay.
You know,
the point is that while we are not saying that, or I'm not saying that the Attorney General briefing the public is not right, but the point is that if preferred charges have been leveled against the accused persons, the Attorney General can come out and say that this person has been arraigned before court, these are the preferred charges, and give all the issues thereof. But before that, if a commentary is run, this person, he has this house here, he has taken money from this place, he's done that, he's done that, he's done that, I feel it is more in law, and just opposing it to Article 19, it is more of brandishing the person in the minds of the public as guilty.
Is that so?
Yeah, as guilty, because the public forms a perception. And that perception is what deals with the innocence of the person before the court even pronounces the person as guilty.
But what's the consequence of the public perception and what happens in court?
Did you watch O.J. Simpson's?
Yes. The point is updating the public is good. Updating the public is good, but that update, when it comes just at the time that the accused person or the suspect, the charges has been leveled against that particular person, and you are briefing the public, that is factual, because that has been done. But not when you are in evidence gathering. That process is not completed. And then you hold a press conference and you make it known to the world that this Mr. A has done this, he's done that, he's done. Before preferred charges are brought against that person, that is where my legal problem is. But not that updating the public about the tools and the knots.
But the Supreme Court itself had been sitting sometimes with television, out there. Like I always say, justice delivery itself is supposed to happen in public.
Yes.
Unless it is exceptionally provided for, then you can do in camera. Yeah. So, in fact, nothing precludes our courts, in order to assuage victims of crime, to allow them to watch the process. It's also part of, sometimes even letting the victims of those crimes feel okay, that justice is being done. So they sit through the process. They go through all that process. It allows, even for victim, offender-victim relationship, and even making it better. Because there are times that when you see this thing happening, the public is will say, oh, our judges are doing well. Because you see, the public doesn't know what the judges possibly do in the courtroom. That is what influences. But if the public sees, oh, the judge, evidence was taken, the cross-examination is what exposed the loopholes in the case, the public immediately begins to form its mind. But when the public is kept in the dark, and eventually a verdict is returned, that's it, oh, the person is not guilty, then the public is say, but see, I say, A, B, C, D. Now, I say, I read it, no buyer. This is what they are saying. So sometimes it's in our own interest, even for the accused person, to see your lawyer punch holes. In the case of the prosecution, for the entire public to see.
Okay. I think we all agree on the fact. I think we all agree on the fact. But it's talking about the timing of the presentation of the evidence. I think we all agree on the fact that there should be updates to the public. But the timing is the thing. My point is that the timing should be when the charges have been preferred, not when all those things have not been done, and yet you come to the public, I've gathered this evidence, I've gathered that evidence, and you try to run it in the public. Let evidence be gathered, prefer the charges against them, and then when you are giving update to the public, it becomes very concretized.
Okay, Lawyer Matibebo, on this particular position, as to whether the AG is on a slippery path, as the lawyer Christian Mamhese is saying, the timing of coming out as against what he says at the press conference.
Good. So let's come with lawyer Chris Mount. Yes, you see his last point. He says he wants only concrete facts. You remember the previous update the AG gave before this one? He made it clear he gave out only those parts he had finished investigation. Yes. Then there were other parts where he clearly said, we've not followed these lines of inquiry, so I don't intend to go there. He was very clear. Oh, but Ayine is an astute lawyer, somebody who is taught all of us here across. Maybe you didn't meet him. Yeah. All right. Ayine is an astute lawyer. You know, you can tell. Your lecturer, if he's good, you can tell. If he's struggling, Ayine knows his stuff. I mean, this is elementary. You don't expect Ayine to come and tell you speculative stuff. So he himself said it, that, look, I talk about only matters I've concluded investigations on. Those I have not, I will not touch them. This is basic. And like I said, you see, this matter, as I've said, for us, the time we're very young on, I still can picture the O.J. Simpson trial and all that. Yeah. So that's what we've grown up with. So it's too late in the day, long before I contemplated going to law school, I saw these things on TV. And so, I mean, you go to America, day in, day out, the DA, the district attorney. Upon the this is what a case happens, they are looking for the suspect. Even when they've not yet found him, the DA is constantly holding press conferences and giving updates. You know, they elect the attorney generals. Yes. So the attorney generals have a responsibility to their constituents to update them. Yeah. That's a district attorney. Yes. That's a DA. That's where we live. I mean, I can picture the, you know, this is America. You live there, you see constant DA is on TV. This particular matter, we are looking for the individual. He's within this area. Even sometimes they can tell you we are circling on him. He's within this area. It's just commentary, running. So perhaps it's our society, because I mean these are things we have grown up with.
In fact, I would have wished that the former Attorney General had put this treason case against me to the public, for the public then to see what
how ridiculous
the ridiculousness of
but you saw how he finally fell. You saw the leak tape. You see when the man is very mean, very mean. You see he gets his downfall. You see how the leak tape now will go before Godfrey Dami for the rest of his life. When you want to use the justice system for political ends, that the finance minister and the Kufuor are on his neck. Finance minister and the Kufuor are on his neck. And you saw how finally he embarrassed himself for the rest of life. Because sometimes, like, hey, Godfrey Dami, you and this leak tape, how are you going to come into court? How are you going to relate to us?
Well, but he still goes to court. Anyway, this is one point that the Attorney General also made. In updating, he says he's going to prefer separate charges against Kwabena Duboahing on the latest relating to the Ghana Water Company Limited deal, some 1.5 million that was being paid into his private account every month for the said supply of internet services to Ghana Water Company Limited. This is what the Attorney General said. Take a look.
This criminal enterprise involved the purported provision of secured internet services to Ghana Water Company Limited by the erstwhile Bureau of National Communications, now National Signals Bureau. The contract document showed that Ghana Water was to pay BNC, that is the national BNC, the sum of 650,000 Ghana cedis every 2 weeks for secured internet services from BNC, that is the Bureau of National Communications. However, for purposes of the payment, Kwabena Duboahing provided the account details of his company, BNC Communications Bureau Limited, to Ghana Water, which religiously paid for the internet services. In other words, every 2 weeks when 650,000 Ghana cedis of money from Ghana Water left the bank accounts of Ghana Water. Instead of going to the National Signals Bureau account, it went to the account of a company known as Bureau of National Communications, owned by Kwabena Duboahing and his wife. Okay? And then they did what they wanted to do with the money. We have made a decision to charge Mr. Kwabena Duboahing and other accomplices in the Ghana Water scandal separately. Okay, so in a few weeks, we'll be filing separate charges against him. And the amount of money in the Ghana Water scandal is in excess of 62 million Ghana cedis. 62 million Ghana cedis. That Ghana Water, that sometimes does not have money to pay for chemicals to purify your water, had to part with purportedly for the provision of secure internet services by a government agency. That's what happened. And so, because the contract documents stipulated that the payments be made to Bureau of National Communications, Ghana Water then demanded that the check payments be made to National Signals Bureau because of the change in the corporate identity of BNC. What then happened was that every time the check was made out to National Signals Bureau, and it landed in the accounts of National Signals Bureau, Kobina Eduboahin, as Director of National Signals Bureau, would then immediately write a check to himself and transfer the money. From our investigations, you can see the movement of the money. Immediately it comes from Ghana Water, he signs a check and transfers the money into the, his personal company account. Now, today something happened in court. Counsel for the defense told the judge that whatever I had said was a figment of my own imagination. But of course, he is entitled to earn his fee. So he can say that. I have been briefed constantly and regularly. I've seen the evidence.
That's the Attorney General. I said you've seen the evidence. And Oliver, you're making a point very quickly on
yes.
writer Bright Simmons had put out. Very quick one.
Yes. I was talking about Bright Simmons writing, talking about how a company with the same name and initials as a state agency which was changed to the National Signals Bureau, we allowed that to be set up, almost cloning the national security apparatus, in order to receive payments in the name of payments intended to the National Security Signals Bureau. It's a bigger issue beyond theft or allegations of theft that goes into bigger national security issues, which must then requires to do a bigger audit of the national security space itself. Because this is something that is compromising the nation's security, I would think.
I see. Thank you. And that leads us to our next issue, because as the Attorney General indicated, in the coming week, for instance, on the matter of the SkyTrain, charges will be preferred now against Professor Amia Akunfi and then the former MD because of this $2 million in there. There was an update on the National Service scandal as well. So I know we'll be getting a lot more updates going forward. But the next issue is the Ghana Bar Association, exactly a week ago, went for their mid-year conference. Prior to that conference, they had issued a statement on the suspension of the Chief Justice that indicated that to the extent that the process is stipulated in law and in the Constitution, they are going to watch keenly to ensure that that process is followed and not politicized. After that bar conference, a statement was issued. In fact, there was news about what had been resolved, but there was no statement. And so even for us in the media, we're just waiting for an official communication from the GBA before we even have a discussion on it. 3 days after that bar conference, exactly a week ago, we got a statement on Tuesday, putting into ink what they had resolved, the resolution, ordering a number of things, Ablikuma North, illegal mining, Boko, and then two issues, that is the acting CJ's directive and then also the suspension of the Chief Justice. This is it. On the matter of the court case assignments, the GBA said they're calling for the withdrawal of the directive by the acting Chief Justice, Bafo Boni, on assigning new cases and advocates for enhanced use of technology in the process. They say that directive should be withdrawn. We'll touch on it. On the suspension of the Chief Justice, the GBA says they are calling for immediate revocation of the Chief Justice suspension, deeming it unconstitutional, and an enactment of clear regulations to guide Article 146 proceedings on the removal of the Chief Justice. Immediate release of the decision establishing prima facie case against the Chief Justice, and the condemnation of political commentary that undermines judicial independence, and a pledge to protect the judiciary from such interferences. They make references to 296 and why the president, in exercising his discretion in this particular case, should have averted his mind to Article 296. But in what respect is the GBA making this particular call? And we'll put that on the screen right now. Earlier when I spoke to Lawyer Xavier Kuju, he speaks for the Ghana Bar Association. What is the Bar Association's position and reason why they are very convinced that what they are asking of the president, and we'll put that on the screen right now, is one that he should heed to? Lawyer Xavier Kuju.
Thank you very much for the opportunity. I think what we meant by that is that, you know, there were allegations or statements that before the sitting president, as we have it now, became president on the campaign trail, he made certain comments that when he won when he became president, he would remove the Chief Justice. I think I've heard something like that. Then the other side to counter that, okay, now that he started a process, when it also come in the future, we'll do same. Those are the comments that we are referring to, that they are prejudicial, and we don't want to hear them from both sides. Probably before we didn't say it this way. That is what we meant.
But well, that's what I'm saying, that in this same statement that you raised this concern, you are also essentially making comments and expressing your opinion about the president's decision, which is consistent with the Constitution, as you have acknowledged that he's done nothing wrong. So why are you condemning something that you are condoning in this same statement?
What we mean, I believe you are referring to what we said, the president's suspension of the Chief Justice is unconstitutional.
It's unconstitutional, yes.
I believe that's what you are referring to.
Exactly so.
Let's put it in the context. The reason we put it that way is that, yes, the president has every right to exercise his discretion to suspend the Chief Justice per the Constitution. But Article 296 also tells us how discretion should be exercised, to the extent that we, sitting members who were at our conference, were of the view that in this particular instance, relative to the suspension of the Chief Justice, the President ought to have caused a publication of regulations in the nature of constitutional instrument or statutory instrument before going ahead to exercise that discretion. So it's not as if we say that he has no right to trigger the process.
I see. But is it in your place as a Ghana Bar Association to declare the president's act in accordance with the Constitution as unconstitutional?
I think that we are not doing this in our capacity as a judicial authority. Many times you hear people say, oh, this is unlawful, this is unconstitutional. It doesn't mean that those people are they conjure themselves into court. Maybe the cost is coming from us as an association. That is why you're having an understanding. There is no way that we can ever equate ourselves with the court of competent jurisdiction. We are just describing what has happened that is unconstitutional. That is our thinking. So should we even decide to pursue it further, maybe by going to court? I said maybe. That may be the grounds on which we'll be going. That does not mean that we have already decided to go.
But well, there are others who also hold the view that, yes, this act is constitutional. What would be the GBA's position on that?
Can you take that again?
I'm saying that as you describe that decision as unconstitutional, others also hold a strong view that what the president has done is constitutional. What's the GBA's position on that?
That is exactly. If you put two lawyers together, you attach on one issue, you have the same position. So that is the beauty of it.
So let me establish this.
At a meeting,
right?
At that meeting, we hold the view that by not publishing the regulations before suspending the Chief Justice, that conduct or exercise of that discretion was unconstitutional. So if there are others who hold a contrary view that, look, irrespective of that, is constitutional. We will not fault them because that's their position.
But can you point to me?
Even at the GBA meeting, different views were expressed, except that just like it happens at any other meeting, whatever majority agree on, that is what carries the day.
But point to me exactly what the president has done that you describe as unconstitutional. Exactly what has he done?
I think that is what I've just said, that the failure to have caused regulations to be published relative to his exercising his discretion in suspending the Chief Justice. But that is why we say so.
But you agree that the regulations you talk about, in the absence of the regulations that you are expecting to be published, the president can only work with what is existing now, is it not, in the Constitution, correct?
Yes, the president has, you listen to me this way, the president has the right to suspend the Chief Justice. So he has that discretion to exercise. But we are saying that in exercising that discretion, he should have recourse to Article 296, which says that once he's not a judge or a judicial officer, he ought to have caused a regulation to be published in the nature of a CI or statutory instrument. That's what we're saying. So we are not saying that he cannot go ahead, but in go ahead, we expected him to have affected his mind to the provisions of Article 296.
Xavier Kuji speaks for the Ghana Bar Association there. Now, they do not question the president's powers, but then again says in exercising that discretion, he should have averted his mind to the dictates of Article 296. Lawyer Said Salahuddin is the fund manager of the Africa Judicial Independence Fund, obviously a private legal practitioner as well. Counsel, good morning. Welcome.
Good morning.
Thank you for joining us.
Thanks for having me.
You had issued a statement, essentially, also siding and supporting the GBA, the position that the suspension of the Chief Justice, in your view, violates the safeguarding of judicial independence, and that this process shouldn't be politicized. Why is that?
First of all, let me state categorically that our statement that we issued did not say anything to the effect of the suspension of the Chief Justice. If you look at the statement, we said that when it comes to the merit of the ongoing process, we take no position on it. And we also stated clearly that so far there has not been any subversion of the process. That's what our statement said. At the same time, we are of the opinion that removing the Chief Justice without tackling the structural issues confronting judicial independence in Ghana would rather exacerbate the situation. But if you ask me about the suspension, for us, the suspension is not a problem. Once a judge is under investigation, that will lead to his or her removal. International best practice in itself requires that the judge should automatically be suspended. What is, however, important to state is that proceedings lasting for a very long time while the judge is under suspension amounts to de facto removal from office, and we must guide against that.
What exactly do you mean by that? That's the process at play, is it not?
Yes, so for the suspension in itself, as it is stated in the Constitution, there is no problem with that. Once the petition has been forwarded to the president, then a case is determined that there is a case for the Chief Justice to answer. A committee has been empaneled. The president exercises the discretion in consultation with the Council of State to suspend. That should not be a problem. What we should be concerned about is that the Constitution did not provide the time frame within which the proceedings should last. And it is important that because the Chief Justice is suspended, proceedings must be done in a manner that is expeditious so that it doesn't last for a very long period of time. Because if you suspend a judge and proceedings last for several years, that suspension amounts to de facto removal from office, and we must guide against that. So the suspension per se is not a problem, but we must ensure that while the judge is under suspension, we must respect the procedural fairness of the process. Want to state that the Chief Justice, even though under suspension, is presumed innocent. That's first thing. We must provide her with reasonable time to assemble her defense and defend herself. We must give her the opportunity to cross-examine witnesses. All of this must be provided for the Chief Justice. At the same time, we must ensure that the proceedings are conducted in an expeditious manner so that the Chief Justice is not suspended for a very long period of time, which in itself will amount to de facto removal from office.
Let me here's what I bring in. That's a quick response to that, because I want to go back to the GBA's position.
I think I entirely side with the concluding statement by my learned friend. Why would you want an impeachment proceeding to drag forever? In order not to create the impression that, like he pointed out, a de facto removal, it's important that the process for the removal is expedited. And so my expectation is that the 5-member committee set to investigate or adjudicate the matters will do that in the shortest, as somebody would say, in the shortest possible time so that it doesn't drag. But more importantly, to the Ghana Bar Association and the statement or resolution
yes,
they offer.
Essentially, they make the point that to the extent that Article 146(10) is a discretionary power, that is not in dispute. Is it therefore in dispute that if it is a discretionary power, it should be governed by Article 296 in its execution?
Now, you see, the Ghana Bar Association is supposed to be a voluntary private association of lawyers, of which I am a member. I think I'm a member in good standing for my last check. Now, having said that, what the Ghana Bar Association, because of its standing, because you see, if you pick the Constitution, excuse my language, Ghana Football Association is not mentioned in the Constitution, but the Ghana Bar is. Ghana Medical and Dental Council does not have expression in the Constitution, but the Ghana Bar does. What it means is that it is a private association that has been exalted to a certain level, and that alone requires sobriety, good conscience, in whatever the bar does. Now, the bar is also, because it's an association of lawyers, when we come out with resolutions, that resolution should accord with law. Because can you imagine association of lawyers advocating for unlawful conduct? Can you imagine the irony of it? That when the association of lawyers met, their resolution is urging a conduct that is unlawful. And why do I say so? The very premise of the resolution is that the president, in exercising his powers under Article 146(10)(a), which had to do with suspension, ought to have published beforehand a constitutional instrument or guidelines to govern the exercise of that power.
Yes.
Clearly, the bar is on a wayward track.
Why do you say
and we should bring them back. You see, this Article 146 has been litigated so many times in our courts.
Yes.
Article 296C has also been litigated.
The same thing.
Incidentally.
The same judge.
Incidentally, if you recall, President Mahama, having remitted the prison sentence of the Muntie 3, Nana Santi Bedietu approached the Supreme Court together with the Deputy Attorney General, the last Deputy AG.
Yes,
Senior Yeboah. And my own senior Eliklim Agbamava went to the Supreme Court saying that the president's powers under Article 72, which enjoins him to pardon or remit a sentence, ought to be done relative to Article 296C. Now listen to what the Supreme Court, the majority of the Supreme Court judges, had to say in response to this very colorful, imaginative legal argument. The court said, and this is the court speaking through His Lordship Justice Bennett, he says, quote, however, a decision should not be construed to mean that failure to comply with the provisions of Article 296C attracts no consequence in all cases or situations. Each situation should be examined to determine whether or not the provision is applicable and therefore must be complied with. Now the court now proceeded by saying, quote, having regard to the wild executive powers conferred on the president by the Constitution, it would be literally impossible for him to function if he were to go to Parliament with an instrument to guide him in making discretionary decisions. The court proceeded. Thus, the Constitution has inbuilt mechanisms to guide most presidential actions, whether in consultation with, and I want you to mark that word, whether in consultation with, or on the advice of, or with the approval of, etc. And once the president, now this is very profound, he says that once the president acts in accordance with a particular constitutional mandate, as in the instance, he is not, emphasis, he is not required to comply with Article 296C. This is a decision delivered on 2nd November 2018. Is the bar president, with respect, and the bar, saying that they are not aware of this pronouncement of the Supreme Court? Because this is the Supreme Court, authoritatively. And so, in the wisdom of the framers of the Constitution, you notice that in Article 146(10)(a), it says that the suspension action is not an action taken by the president alone. Can you read it?
Article 146, and we'll put that on the screen.
Article 146(10)(a).
Article 146(10)(a).
Now you know.
We'll pull it out in a bit. And it's essentially in
so if you
acting upon the advice of the Council of State.
It says that the president, when it comes to a decision to suspend, must act in accordance with the advice of the Council of State. Has President Mahama done something contrary? So where from this lawless resolution by the Ghana Bar Association telling the president that having acted in accordance with the advice of the council, you should revoke that? What the Ghana Bar Association is effectively doing is to invite President Mahama to engage in unconstitutional conduct. My question is, why would the bar be the one advocating for such unconstitutional conduct? Because, like the Supreme Court in the early claim Agbamafa decision versus Attorney General rightly pointed out, he said the Constitution itself has an inbuilt mechanism to check the exercise of discretion by the president. And that in those instances where the president acts on approval, in consultation with, on the advice of, in those circumstances, the Supreme Court said he is not required to comply with Article 296C. Is the bar saying they are not aware of the decision of the Supreme Court? But how embarrassing can it be that the Ghana Bar Association, an association of the creme de la creme, as far as law in Ghana is concerned, can drive itself in such a legal quagmire? Why would the bar get involved in this? But you see, the reasoning is simple. Much earlier, The MPP minority in Parliament, led by my senior Bafo, has started poisoning the atmosphere with this legal reasoning that the president, based on Article 14610A, is required to comply with 296C. But like the court rightly pointed out, because this action to suspend is not a presidential decision stand alone, but a decision done on the advice or approval or consultation with a kiosk. So the Supreme Court then proceeded to say that the reason for 296 is to ensure accountability.
I see.
To ensure that so this is what the court said, and I'll read. It's a quote. From the foregoing, the proper exercise of discretion should be marked by fairness and candor. And thus, any conduct in the exercise of such discretion, which may be described as being capricious, born out of resentment, or by personal dislike, or fall short of due process, is not proper exercise of discretionary power and constitute abuse of sin. The rationale for Article 296 is to check the abuse of discretionary power.
Yes.
And that is why the court reasoned that the inbuilt mechanism allows for this. Where is the essence of fairness? The essence of fairness is the president is in receipt of petitions. His spokesperson announces that the president is in receipt, and by law, he's supposed to consult the Council of State in a determination of prima facie. Immediately, the Chief Justice became aware. She personally wrote a letter copied to the Association of Judges and Magistrates, and I think the Ghana Bar Association is up. And now ask the president that give me the opportunity to have a say. That's fairness. That's the requirement of hearing.
I see. But
that is not a decision that you can say is tainted by resentment or whatsoever.
How would you respond, I mean, to the legal positioning that, having admitted, because all across the table we all admit that 14610 gives the president discretionary power to so exercise if he decides, or he may decide to do so. If the president having the power to suspend the Chief Justice is discretionary, how are we going to measure that exercise of that discretionary
so the
power?
answer is in the decision of the Supreme Court. It says, quote, most presidential actions, whether in consultation with or on the advice of or with the approval of. So if you read, the framers of this constitution are very wise people. They anticipated these situations and ensured that when it comes to the suspension of the CJ, the president should not act alone. He should consult. So the Supreme Court is saying in those circumstances, you don't need to go back to 296.
But now, does it answer the question of whether that discretionary power being exercised is done so candidly, fairly?
No, so that is why I answered that question.
And not arbitrary.
If you were listening, and I know, is that I gave an indication that you remember that the Chief Justice had indicated to the president that I want a response. She even said 7 days. The president said, I'll give you 10 days. Gracious. That's procedural fairness. That's procedural fairness. So in this case, the decision that was taken relative to the determination of prima facie is not a standalone decision. I remember vividly when her ladyship Sofa Akufu determined the prima facie against Charlotte Osei. Charlotte had demanded copies through the presidential, the president.
And then Eugene Ahin responded.
And Eugene Ahin responded and said, at this point, that is not the president's duty to furnish you with copies. 2, after Sofa Akufu made a determination of prima facie, and I've heard her make the comment that the procedure for removal of CJ is unfair or something.
Oh, she's been talking generally.
No, I'm coming. You see, my point is, she had the best opportunity to call for reform. because she made a determination of prima facie against Charlotte Osei. I remember my lady senior Tadio was the lawyer for Charlotte Osei. When they appeared before the Justice Anthony Bennett committee, Justice Anthony Bennett, Mafosa, Agnes Doji, and 2 other people, it was then that Charlotte had the benefit of the petition and who the petitioners were. At the committee level, with her lawyer. It was then that His Lordship Justice Bennett now started putting the procedure to guide their work at the committee level. At that time, her ladyship, Sophia Akufo, was graciously in that process. I have always said that for a president or whoever to get involved in the removal of another person, it's like Pontius Pilate. It is not a duty anybody wants to perform laughing. It takes a lot of courage to comply with that constitutional dictate. But I've always said, President Mahama has demonstrated consistency indeed. How do I say, why do I say so? If you recall, when the MPP, my MPP brother, Richie Nyama and Frank Anodompre, brought the petition for the removal of Vivian Lamptey, Loretta Lamptey, the Shrag was appointed by President Mills. President Mahama didn't say that the petitioners were NPP ideologues. He received it. And in the case of Loretta Lamptey, President Mahama, after Georgina Wood CJ made a prima facie determination against her and set up the Niyebua Maria Mowusu Benin committee, President Mahama suspended her. So, consistent with the conduct of President Mahama is what we are. The Ghana Bar Association felt that as for Shrag boards can be suspended, as for Electoral Commission board can be removed, but a CJ cannot be removed by following the constitutional requirement. How convenient is that submission? Let me conclude on this last one. The bar in the resolution says they are urging the acting, what do we call it, Chief Justice, to immediately revoke the manual assignment of cases.
Yes.
Our bar, the bar I belong, should not become a willing tool for manipulation and demonstrating obvious hypocrisy. Why do I say so? I have with me, Alfred, and maybe later you can project. I have with me a statement or a circular issued by Her Ladyship, now suspended Chief Justice, Gertrude Araba Tokono. And this is a circular she issued barely a month after she became the Chief Justice of Ghana. Would you permit me to read?
Go ahead, yes.
Okay. Just 1 minute. I'm just pulling it up.
And while at it, let me acknowledge our listeners as well on the Voice of London Radio. We understand we're on TV as well there. So
now, now let me read. Circular is dated 28th July 2023. The Ghana Bar Association was in existence or is in existence or whatever then. C distribution. Notice of suspension of electronic case distribution system. Respectfully, I write pursuant to the directive to suspend the electronic case distribution system. I've been directed by the Honorable Lady Chief Justice to inform you that the following supervising authorities are hereby mandated to take over the manual distribution of cases with immediate effect. Greater Accra Region, High Court Complex, Mrs. Patricia Dawson, Court Manager. Then it goes, Ashanti Region, Her Ladyship Justice Angela Mensah Homia. So this thing that the Ghana Bar Association hypocritically is basically urging on the new or the acting CJ was a position that the now suspended CJ in 2023 took
So essentially, it's not new.
No,
in that sense.
Manifest hypocrisy. Is the bar telling me that in 2023, when this circular came, they were not aware, or they were deeply asleep and are just now up? Please, let's be fair.
Okay.
We are building a democracy.
Thank you.
A democracy that should have inherently a semblance of fairness. I'll conclude on this. When President Mahama appointed his Lordship Justice Yao Apao and Justice Puaman to the Supreme Court, the Ghana Bar Association, then led by President Nana Megache, said President Mahama could not have done the appointment the manner in which he did. Why? Because the Judicial Council brought recommendation of 4 and decided to rank them. President Mahama, having received the rank, chose there were 4. So he took 4 and 2nd. Then the bar said, because they have recommended, the Judicial Council had recommended, the president is bound, even if he wanted to choose from 1, 2, 3, or 4. And so he didn't have the right to do 4 and 2. The bar led by Nana Megache went to the Supreme Court to challenge President Mahama. How come that the bar is only up when President Mahama is the one acting?
Because he's more tolerant.
Let me get it. I'm not a member of the Ghana Bar. They all are. So,
Christian Mohammed says that call on the suspension is not essentially a demand. He says it's an appeal. From where you see, you see
a resolution.
A resolution cannot be an appeal.
Why do you describe this resolution on the revocation of the suspension of the Chief Justice as an appeal by the GBA and not necessarily a demand whatsoever?
Okay. All right. I would want to read what Article 296C says. It says that where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution, or that other law to govern the exercise of this discretionary power. Now, this particular provision is what the Ghana Bar Association based its resolution on. And my point stems out of the Ransford France versus Electoral Commission and Attorney General case. That was in 2012. And the lead judgment was given by Justice Dateba. Now, Justice Dateba indicated that when it comes to Article 296C, in respect of the exercise of their discretion, which involves public officers, that particular provision must be interpreted purposively, and that we have moved away from literal interpretation. Now, he traces Article 296C to the 1969 Constitution of Ghana. Now, and he further indicated that if we look at the Constitutional Commission memoranda in 1968, prior to the 69 Constitution, it put out how the Article 296, as it was in the Constitution, being Article 173, how it ought to be interpreted, and that in looking at it, it meant that it was to give public officials the opportunity to exercise discretionary power, and such that it will not be capricious, it will be fair and not out of dislike for whoever decision is to be taken against. And that in such situation, if regulations or constitutional instruments is to be associated with that which a public official takes, the exercise of their discretion that is taken by such a person, it would cause what he described as a nuclear meltdown. And it will create chaos in the governance system. And that where that happens, the non-compliance with Article 296C cannot invalidate such decision taking out of Article 296, as in a discretionary decision taken without such instrument cannot be rendered invalid, because when that is done, that would be a literal interpretation of it, and that literalist interpretation has no place in constitutional interpretation, because when it comes to constitutional interpretation, we deal with the object and then the subject, and based on it, the objective deals with what the framers of the Constitution thought of, and then the subjective deals with the legal, the historical antecedents, the context, and the text.
But in further detail, at least in that Justice Dateba ruling, he also went further to talk about something related to the effect that it is when that body is exercising a quasi-judicial function that it may be necessary.
Yes.
In that respect.
So it indicated that
some more context
it indicated that when it is an adjudication, when there is an adjudication, the president is not an adjudication body or authority. And it further indicated that when there is an adjudication, then that adjudicating body could use Article 296, but not an individual or public officer who takes discretionary decision day in, day out. When that happens, it is going to cause a meltdown in the governance of the country. And after that decision was taken, then came the case that the Elikplim case, you know. So it found its roots. It came out of that, and so by my conclusion in the article that I wrote that the 3 News published, my basic position is that, I mean, the GBA misfired as far as this is concerned, and the best that it could be seen as, even though it's a resolution for whatever it's worth, it can best describe as an appeal.
But the wording,
I mean, to take it on a lighter note.
Well, yes, but the wording in itself doesn't tick the box for an appeal. That's where
that's what I'm saying.
It imputes impropriety,
yes, it does,
against the president.
Yeah.
The time the Ghana Bar Association knew that the Supreme Court has authoritatively pronounced on the matter, it's mischief, and we should call it as such.
Professor Bafo Ajimendia is joining us on Zoom right now. Prof, good morning, welcome. He'll put the video on, and Oliver, on this particular position by the Bar Association. The point they make is that to the extent that 146 is a discretionary power, and the GD has dealt with it quite extensively, elucidating and making references to a number of pronouncements by the Supreme Court already. But the GBA is convinced in its mind that the president acted arbitrarily and unfairly in suspending the Chief Justice.
You know, if one forgets the history of the Ghana Bar Association, one might be tempted to take them seriously on issues.
What do you mean?
I mean, listen. This is a member of the Ghana Bar. Yes, you are a member of the Ghana Bar, and I've made a historic decision not to join a member of to be a member of the Ghana Bar Association, because it's not an association that represents my values and has never done so. I don't know when the last time you spoke up for justice in this country. And in fact, first of all, before I come to the substantive points, I would think that I would blame members of the Ghana Bar Association itself.
Why?
Because, including Eduji and others, you have 47 people who have gone on and decided to put out a statement like this. And we may be dismissive of it, and we may think it laughable. You describe it. It's so dismissive that let's say it's even
somebody
an appeal.
says an overaged breast.
That domestically, we may be dismissive of it. But we must understand that for posterity, history, and also international audience, we cannot leave this thing to stand. The bar statutes as a process by which something like this can be overturned. That you need 30 people to call for a special general assembly to overturn this. The vast majority of lawyers are telling us that they don't associate themselves with this statement. History demands that you cannot allow this to continue to stand. The bar, members of the bar must mobilize and call for a special general assembly to address this thing. Let us not treat this as policies as usual and let it go. Because we are failing to understand the institutional role it plays and what its voice might carry for posterity. The president has an interest to ensure that when history looks back at this, nobody then turns around and says that, oh, all you did was that you destroyed the judiciary's independence, and this is proof because the Ghana Bar Association even called you to tax. So let's not leave this thing to stay. In fact, if I was a member of the Ghana Bar Association, I would have already mobilized and for the convening of a special general assembly on this thing. So it's serious. Now, this is not the first time there's been practice around Article 14610. President Akufo-Addo suspended Justice Derry and several other judges under Article 14610. The Constitution says that when it comes to the Chief Justice, he does so in accordance with the advice of the Council of State. When it comes to every other person, he does so on the advice of the Judicial Council. He, relying on the advice of the Judicial Council, then suspended all these other judges. At no point was there a conversation about why didn't you then put in place regulations before you exercise that power? History does not show us at any point that the bar then convened in respect of those judges and determined that the president had then violated any law. So why is this coming up now? You have to understand the history and trajectory of the bar's relationship with the intellectual left and also the NDC. If you look at the bar's history, and I've said this, there's no point in the bar's history where it has gone to court to challenge anything done by a president and an MPP.
There's no history.
There's never been that. That's true. Okay? Now you can say that, okay, we are in a country where executive abuses of the Constitution are routine. So sure, it is not only the NDC that is going foul of the Constitution. So why is it the bar only speaks out against things that are done by the executive when the NDC is in power? Look at the history of the bar. The history of the bar is that there was a point during the PNDC, of course, there was no political parties allowed. And so for those who were unaligned with the government then, the bar then became their vehicle for expression of political dissent. And so then under the PNDC, all those politicians, and if you look at the leadership of the bar, when the MPP was formed, all of them became leading members of the MPP. So just political history and political economy of the country will tell you, and the bar itself will tell you that, no, this is an institution that historically has been aligned with the political rights in this country. And you can take it on its face value. Let's enough talking about, look at the judicial appointments that he talked about. How many judges did Akufo-Addo not appoint in this country? But the only time, in fact, Raymond, my own mentor, Professor Raymond Atuguba, always tells me that they're always surprised that when President Mahama was in office, they only appointed Justice Poaman and Apau to the Supreme Court. Yes. And they never even thought about the president being so involved as to pack the court. It was so unconscionable for us to think the levels with which the courts were packed under the former president. All of this, the bar stays silent. In fact, when somebody in Parliament said that a Supreme Court justice had called her to convince us to vote a certain way in the election of the Speaker of Parliament, without any evidence, the bar issued a statement criticizing the Member of Parliament. Manasseh's book, which he has published then, actually provides, in fact, what that judge was, and that this, in fact, did happen. But the bar stays silent on all of this. Now, I will go back to the Constitution Review Commission, which I was part of. The Constitution Review Commission reviewed this very constitutional framework around the Chief Justice. And this is what it says. The Commission is convinced that the situations that can constitute grounds for a petition for the removal of the Justice of the Supreme Court in Ghana today do not unnecessarily put justices at risk of persecution or political manipulation.
Right.
This is the Constitution Review Commission. So I don't understand that when we are applying the law as we have over 30 years, considered as to be fair to the Chief Justice now, we are creating then a problem as if the Constitution is wrong, the law is wrong. Exactly. But not that we cannot have the same framework, check and look at misconduct. And I've been clear and consistent that nobody can say that's a foregone conclusion that the Chief Justice is gone. If the President had gone on and appointed Asiedu Nketia, Fiavi, and some other persons who are non-affiliated to the NDC, to the committee, we would then be saying that, it is a foregone conclusion that these three people are political appointments and are aligned in a particular way. The President has been so fair that When you look at the persons who are appointed to the committee, the non-judges, nobody can criticize Domelevo. That's his consistency and his aptitude for fairness is clear in this country. He's appointed a representative of the Ghana Armed Forces.
Major Flora.
He's appointed a member of academia. All of them. Nobody can call any of them as known political persons.
Professor James Sefajisa.
Now, as a political realist, I would think that the extent to which the MPP is politicizing the process, that if the Chief Justice is cleared at the end of the day, it will seem as if it is a victory for the MPP, and for which reason, just by their conduct, I would ensure that she goes. The President in his wisdom has not even gone down that lane of thinking, but has been a statesman in this matter. So why are we doing this? That's where my struggle is. Why is the necessity for what has been put before us today?
The resolution has not been basis.
Now the question as to whether or not the Council of State, it was proper for the Council of State to even recommend her suspension. Even though, we are being told that, in fact, international best practices say that suspension must be mandatory. In our case, it is even subjective, right? Like they must consider the facts. What has happened? When the Chief Justice then, when the petition was brought to the President, the Chief Justice then wrote a letter, released it in the public domain before sending it to the President. It's not people say the Presidency has come out. That they had not, in fact, received that letter that she had sent to Madame Sophia Akufu, who's on the Council of State, personally to her, not even to the Council of State, to the Ghana Bar Association, to the Association of Judges and Magistrates, and then publish it on the media. For somebody then, immediately before we even knew, and even before her statement had been issued, certain members of a member of Parliament and the former Attorney General had gone to court claiming that the Chief Justice had not been given hearing yet. Who knew about this?
Are they in communication?
Are they in communication with who? So how did they know and go to court? When they realized that, okay, how did you know what's coming up in the public's mind? She then went to release that statement and put it in the public domain. To the point that the President then had to, in sending the petition, said that by your conduct, I am marking the documents confidential.
Yes.
So then, in fact, invoking our security designation classification of documents, because this is how much the Chief Justice was not trusted to keep these documents private. It is this series of conduct, I believe, that will then convince the Council of State that, listen, this person has showed by consistent conduct that if we are not careful, she can torpedo the process against us. This is the reason why international best practice will recommend the suspension of a person, because of the risk involved. So it is not even if you're going back to look into the decision of the Council of State, nobody can say that decision was arbitrary when one practice shows that it has been exercised before without any question. Well, but if we allow this to stand, that's my last point. We allow this to stand, it shows and confirms for me the continuing disgraceful conduct of not only the Ghana Bar Association, but of its members. Because if you say that you think that this is unconstitutional and wrong, then your own statutes allow you to correct this. If you allow this for tomorrow posterity to have a different comment on this, then I have you to blame.
Well, that's what you were recommending, that they should call an emergency meeting.
Yes.
Convene the other members, because it's just about 47 of them who reached this resolution. They formed a quorum, by the way. That's what we're told.
No, that's not the point. The point is that the decision that this is not only undermined by its ridiculousness and illogic and its illegality.
It's not supported by law.
But it's not supported by law, but also it is not constitutive of the vast majority of members of the bar. So if the vast majority of members of the bar have a certain opinion, and we have allowed certain persons to, in fact, that Saturday I was on Newsfile. The former Deputy Attorney General was also on Newsfile with me. And she was talking about how she needs to rush quickly and go to this mid-bar conference. And that people were calling her to leave and come for it. They knew what they were doing. They intentionally then decided to take the protest that they are going to be doing on May 5th to the Ghana Bar Conference and started the protest from there. So you have allowed, it makes it so easy for people to weaponize the bar and use it for political ends. This is the disgrace that the bar is to me.
Professor Bafajmandia, good morning.
Good morning.
Thank you. I know you've been on listening to the submissions made by the previous speakers, but this is what Professor H. Kwesi Prempeh, who is leading this process of engagements for the Constitutional Review Committee, put out on this matter. And we're going to put that on the screen right now. It says, quote, how exactly is Article 296C supposed to apply
to a suspension decision pursuant to Article 146. Is it the Ghana Bar Association's position that every time we read may, quote unquote, in the Constitution, Article 296 is triggered? So if a provision says Parliament may, quote unquote, do X or Y, Parliament must publish regulations under 296C prior to doing X or Y? Really? He goes on and references a number of the cases that Lawyer Edudzi Tamaklo has also eloquently stated. Prof, what exactly, is there any real concern about this process triggered under Article 146 and the President acting in consultation and upon the advice of the Council of State?
Well, good morning to my very good friends on the panel. And please indulge me when I say that, look, I'm not competent to get into the legalities of this matter. I do appreciate the comments the panelists have made.
And that's a fair point.
Pardon?
It's a fair point, indeed.
Yeah. I am learning here, listening to my good friends there. First of all, it seems to me clearly President Mahama has not erred. In fact, he has followed the process. So I don't find any fault with what he's done. He's just followed what the Constitution requires him to do. Nonetheless, what is a lesson here is that the whole question about a Chief Justice in any democracy is a very sensitive issue. And if you go back into history, you'll find incidents where presidents, not only in Ghana history, but elsewhere, where presidents have been very, very cautious, taking any action that may look like interfering in that, only because we all regard the three arms of government, while they are not equal in many ways, they are important, and the three of them work to check each other. And more importantly, we operate on the principle of the independence of each of them, okay? So in the balance of power relationship, we want to see that independence. That is where my main concern is. So as I said, the president has, from my limited perspective, I think the president is doing what he's required to do. But my problem is with a system that allows this whole thing to happen. And I think many people are now beginning to think, including myself, that perhaps we have to look at the Chief Justice in a different way when it comes to appointment and removal. I think we have to find a way to isolate the executive from ever interfering. I know the checks that this Constitution places on the process, consulting the Council of State, taking certain actions and all. I am very much aware of that. But nonetheless, once the executive appears to be part of the process, it creates all these kinds of concerns. That's why I think, even though it is true to say for the 32 years of our republic, we haven't had any problem with the Constitution regarding the Chief Justice and all, I strongly believe that with the new opportunity offered by President Mahama to review the Constitution, we must look at how we create a new structure of relationship that will insulate each of the three arms of government from each other. For me, that's the biggest interest that I have. How do we ensure? In fact, if we can cite examples, Kenya, for instance, when they want a Chief Justice, it's not the President who appoints the Chief Justice. They have a system through their own judicial councils, where it's advertised, people apply, they have conditions, criteria, and then they select the best one, goes to Parliament for approval, and of course the President signs on. I think that's a better way, because if you look at the politics of our country for the past 2 years, whether we accept it or not, we have politicized almost everything. Almost everything. And listening to the commentary that some of my friends they have made, it's true that in this republic, I didn't want to go there, but the GBA seems to be interested in cases when a certain party is in power and that kind of stuff. So let's find a way to just create a new system that will allow us to have a true independent arms of government. And there should be no interference from one on the other. Of course, if we had that system, and we find a Chief Justice misconducting himself or herself, that same system that the new one we have that appoints the Chief Justice should also have mechanism for dealing with misconduct so that the executive will be isolated from these kinds of issues. For me, that is my biggest concern here.
And so you also align with that concern or the sentiment about the conduct of the Bar Association sending a certain signal of how they act when a particular party is in power, and in this case the NDC?
Well, listen, we've been in this country for, well, I've been here for I don't know since when, and I follow these events. And clearly there's some concern about that, okay? I'm not hiding. There's some concern about that. And because I'm not a lawyer, I don't want to get into the legalities. But clearly, if I follow the trend, if I look at the process in this particular case, and I followed it very closely, I don't see where one can question the president about the discretion that he made in triggering this process. I don't see it. Maybe I don't, because I don't have legal eyes. So I think we should allow this case to proceed. For me, it's great that we are proving something to ourselves as Democrats, okay? An issue has come. This is testing the resilience of ourselves as Democrats, the resilience of the system, okay? And I think we will get through this, not seriously damaged in any way. But at the same time, I strongly believe that it is time we relook at the appointments and, that we have argued over the years that our president has been given excessive powers. And I don't see why we cannot begin to look at, in this particular case, creating a new system that will insulate one from the other in terms of, because we need to really preserve these three arms of government. I think for me that should be the future.
But in respect to this particular process, is it just the constitutional dictates at play and the president following the dictates of the Constitution as has been stipulated? That's the point you make. Nothing done wrong.
Oh, correct. It's the same thing. I mean, when in the previous government, some petitions were sent to President Akufo-Addo, he indicated that, look, I'm just a conveyor belt. It came, because that's what the Constitution says. You remember that? So I had a problem with that, by the way, because I've made the argument that even the threshold for really establishing the prima facie, I think is wrong. I mean, if we are really treating a Chief Justice as a head of one constitutional body, I mean, EC or any other kind of institution in our democratic system, I think it's wrong. I place the Chief Justice very high because these three really make up what democracy is all about. That's why I'm thinking, and I believe that we should create a different threshold for removing these individuals, and especially making sure that each of them will be insulated from the other, so that the independence will be there. Look, our politics in this country today will never satisfy any faction when it comes to these matters because we have politicized everything. In the case that we're talking about, like I'm saying, I don't see anything wrong with what President Mahama has done. Look at the other side. And I think we can avoid all this by creating a system that simply creates that independence, at the same time ensuring that the checks on misconduct is also placed within the new system that we create for the Chief Justice.
Well, there's a concern that I know you align with about the review of the Constitution in the appointment of the Chief Justice. But then again, you hear Professor Bafo Agyeman-Duah talk about the legitimacy of the sentiments about the Ghana Bar Association, its conduct with respect to when a particular party is in power and how they also conduct themselves when another party is in power, and in this specific case, the NDC being in power and the position they have taken, which clearly, as has been elucidated by both all three of you who have earlier spoken, flies in the face of the position of the Constitution. Why is that the case?
He mentioned, he gave the answer to, it's a politics. You see, So we're doing all these things. When I say we, that's the people actually at the bottom of this. Okay, for selfish ends, you say, yes, people will twist what the Constitution says. People would, and that's the nature of law, all right? That is so flexible, okay? It accommodates. The meanings expand. So people with various interests can hide behind the law. That's it. So it's about clarity of thought, you know, the way the law is expressed. So if it's not expressed in such a manner as to give only one clear meaning, then there's room for people to come in with their political ends, right? So you see, in all of this, for me, what I see, so from when earlier on I'd made that point, and it's a point we've been making months before, and even in other fact, if we go back, we see that for years, other commentators have been raising this. We will have to amend the Constitution in that regard. That one is no-brainer. It's clear. So we are talking about Article 144, right? Yes, that's where you have the President acting in consultation with the Council of State, all right? And with the approval of Parliament, the Chief Justice, right? Then you come to the other Superior Court justices, etc. We have said it, thankfully, it's something we've been saying for some time now before this matter came. So nobody can say that, oh, we are also on one side or the other. Because the thing is so, it's unwieldy. It's unwieldy. If you talk about separation of powers, then you can have the head of the executive, right, play a crucial role in the removal of the head of a coordinate branch. That's the judiciary. Then it means that we almost have no separation of powers. So you remember when Chief Justice Tokonu wrote the letter to Akufo-Addo last year, and then we had to debate it. That's a list of 5. Yes, I kept using this phrase that in Ghana, our constitution is modeled in such a manner that you buy one, then you get one free. Buy one, get one free. Yeah, you buy the executive, so you are president, then you get the judiciary for free. Yeah, that's it, for free, through appointments and also through financial inducements. So yes, only buy. You buy one, get one free. So it's good that we started making this noise, and I mean, this case has brought the arguments back. And so I'm sure Professor Kwesi Prempeh is following. Yes, and I'm sure even he would have this debate himself. He had shown through his various submissions and etc. that it's not a system that he likes. No, nobody likes such a system, because to build a stronger society. Yes, we've made some progress, but naturally, you know, this constitution, the Tonyedi doesn't like hearing that, but it's generally accepted that it was written to appease Rawlings, okay? But Tonyedi will tell you that no. But of course, we are Ghanaians. Others can also read and make their own judgment, right? So now that Rawlings has been off the scene for some time, we need to rework it and give stronger independence. Because, look, the politicians are not angels. And none of us sitting here is an angel. So we need to write the constitution in a manner to reflect that we are human beings, not angels. This constitution is written as if human beings, where our presidents, our politicians will be angels. So in other words, that's why we've been talking about the philosopher king. This is a philosopher king kind of a constitution. Yes, but we are not philosopher kings. We are not. Lots of us fall short in various areas of our lives.
So why is the GBA's position a departure from what the law is?
Yeah, so this
on the
GBA
revocation of the suspension.
You see, the GBA thing, I like the interpretation Lawyer Mann is put on the GBA thing. So perhaps they shouldn't have called it a resolution. You see, what the GBA has said, look, to be very frank, speaking openly, and because this is a matter we had been raising here before Chief Justice Tokonu's matter came, you can see that I have a soft spot for it that we should tighten the constitution. A soft spot for it. But the GBA went too far by calling it a resolution. You see, so you see what Lawyer Mann is saying, that it's an appeal. They shouldn't have called it a resolution. The moment you call it a resolution, at this time that we are saddled with a hard case, then people will read politics. Especially, it doesn't help if Wagati, you see pictures of her with her husband on a campaign platform. If Wagati in MPP colors, you see, Gatti, so that's wife of Joe Gatti. Joe Gatti was what? Former Minister for Railway, former Attorney General, former board chairman of GBA, etc. You see, yes, and to be honest, look, I don't hide it. I supported Gatti to be president. I supported her. You know why? You know, I always like balance. By the time does this, listen, I knew NDC was going to win, even if by 100,000. It was clear that with the misgovernance and everything, NDC was going to win. So I wanted opposition. So I said no. Ifua comes from MPP, so I wanted, but I didn't know she would descend this no. So if I got it, this one, yeah, no. That's not how. That's
are you by this withdrawing your vote?
I'm not withdrawing. So you know that I still support her. We need, you see, like Lawyer Mam said, you should have made it an appeal. I have a soft spot for what you're saying, that we should tighten the rules. We have been saying it here before this matter came. But to call this a resolution, no, it was too much. 47 people. Even look at the way people, lawyers are raising arguments about the timing of the conference. People didn't get enough notice, etc. So that one, this is. I call it
Diana Asunaba resolution.
I know.
That's
it's interesting, you know, politics. So if we are this one, let's have another meeting. We'll cancel it and call it. If you call it an appeal, I'll be first to sign. If you call this an appeal, I'll be first to sign, because every Saturday I come here, this is a matter we have been raising. That no, let's strengthen the constitution. The president shouldn't have a role. Chief Justice Tokonu also said it in 2023 at a vetting. The president should not have a role in this. It's something we've been saying all along. But don't call this a resolution. You won't get my support for it. You won't get. I mean, so now you see how they've embarrassed Gatti in her MPP colors on the campaign platform.
No, but you compare her first statement, her initial statement, and this one. The initial one was basically telling all stakeholders, hold on to the process integrity. And for me, in fact, I felt it was so measured, fair comment, fair to all sides. Have you heard President Mahama? From the time the notice of suspension came, or from the time he received, say the Chief Justice is guilty?
No.
Never.
No, it wasn't.
It is for good reason. Allow the process. Trust the process.
Yes.
That is what you do in a democracy.
Yes.
Have you heard President Mahama on platform attacking CJ before or prior to? No.
No. No.
In fact, in the case of CJ Tokono, for the record, her approval in Parliament was bipartisan. Was bipartisan. Both NDC, MPP, MPs, even in the hang Parliament, unanimously supported her approval to become the Chief Justice. It was a greater confidence in her. President Mahama, as we say, anticipated that the things in the petition will happen. Is it by way of clairvoyance?
You make
okay.
Point.
Yeah. So moving on. So let's just see, you know, how we move forward as a society. Because listen, no matter where it is, you know, bottom line is the interest of Ghana. That is what we all must look at. The interest of Ghana. You cannot use the GBA. Look, I have my phone full of messages from lawyers and lay people. Very, very disappointed in the GBA. So look, if we are getting this one, you even must be the one to even ask for the next extraordinary meeting. Yeah, she should lead it, because now you've been embarrassed too much. We can't take this from you. So she should lead it so that we'll reconvene. Then we'll cancel this resolution. We'll cancel it, because you can't put the bar into such a, what you call it, disrepute. Look, my phone is full of messages from lawyers. People are very upset. People are very, very, very upset. Maybe you should interview Efua that, look, why did she drag us into this kind of thing? I mean, yes, we want some opposition. We don't want a GBA president who is not to be aligned or secretly aligned to the NDC. That's why I supported you, but not this type. This brazen kind of partisan, like it looks more like MPP agenda. No, it doesn't look good. It doesn't look good on the bar. I think we have to reverse it, like the way Oliver said it. And I think it will restore credibility to Gatti herself. If she leads the process, yes, you send a resolution at the request so that people would request, and then it will be seen that you listen to the bar, and you heard that, well, where the bar went with the purported resolution, it's damaged us. So you also lead the rehabilitation so that we go back and then undo this, because otherwise, I mean, it will go down in history that you came and all you sought to do was just a partisan agenda for the NPP. Yes, because that's what it looks like. It doesn't, I mean, come on. It doesn't look good. Because if you see Ifuagati in NPP dress all over with her husband, it looks very bad. It looks very, 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 very bad. Very bad. Let's do something to restore confidence in the bar association. Because now, you've given opportunity for lay people to take pot shots at us. Pot shots. Everybody say everything. The bar is disappointing. The bar is hypocritical. The bar is NPP. All that. No. Let's do something about it.
Okay, now, and let me, so that I'll just run up. And there's another aspect of the demand of the GBA that we'll get into. So to the extent that the suspension could be described as merely administrative, and the president doing so not alone, but in consultation with or acting upon the advice of the Council of State, it's essentially perfunctory.
Absolutely.
So why should a perfunctory administrative function be administered by a legislation?
I think that His Lordship Justice Dateba envisioned a situation we have today. So if you look at Ransford France, and just for the record, you know the lawyer who argued Ransford France? It was my company law lecturer then.
Your senior was him. He came by amicus curia.
So that time, the EC had decided to create the 45 new constituencies in 2012. Then Ransford France, led by his lawyer, the Honorable Joe Gatti, my company law lecturer then, approached the court and said, the same Article 296C should invalidate the process because per Article 47, the Electoral Commission had not come out with CI to guide the May appearing in 47 on the creation of new constituencies. And then His Lordship Justice Dateba also, even for the sake of argument, assuming there is even a non-compliance, it does not invalidate the decision taken. It's clear in the decision. Then he now proceeded to now draw the categories and say that, but if you're a quasi-judicial body, at least let people, so the Judicial Committee, for instance, of the National House of Chiefs, you should have some CI, at least, so that persons appearing should, for instance, have an idea. If there's a petition against me, what's the timeline to respond? Like CI 47. So people can prepare. And these things ensure procedural fairness. Right. This thing ensures a certain level of candor. However, if the decision is not adjudicatory, then the requirement of 296 does not even come in. More importantly, Alfred, is the question that, and in this specific case, where the prima facie determination is not adjudicatory, and in this, you know, like the particular case of the CJ, with the opportunity to appear before the committee, she'll go with her lawyers, she'll call witnesses, the petitioners have the opportunity to call witnesses, their testimonies will be cross-examined. At the end, inferences will be drawn from the evidence. That's adjudicatory. So there's so much clarity.
That place, I'll disagree a bit.
What?
You see, when you look at it, if we are talking proper, if we are talking pure law, as I said, not in it. When you take a decision that affects somebody's rights, okay, a decision, anything you're going to take that affects somebody, is judicial or quasi-judicial. There can be no argument about it. So if the person is CJ, and you are suspending the person, there is some quasi-judicial...
hold on. In Ransford France, no, I beg you.
France.
No, hold on, I'm coming.
Proper,
no, so I am coming. But you see, His Lordship Dateba, when he said reference to quasi-judicial, he proceeded that by quasi-judicial, I mean adjudication.
Yes, so the suspension is an adjudication. I'm telling you.
Which one?
You look at the papers and come to it. No,
the suspension
it's an adjudication. On the
what point does the
you see, a prima facie. No, hold on. A prima facie can be determined but you decide not to suspend.
Yes. In the case of the word is determined. You see, let's not mix them.
Okay.
How? The word determined. It's
we take decisions every day.
One of the things I'm worried about, or thinking about, is what would regulations look like, and how would they apply in this particular context? And that's Professor Prempe's point on this thing. What would the nature of it be, the decision whether or not to suspend the CJ?
Oh, certainly you can do something about it. So let's come this way. Number one, I want us to go first principles. The question is that in law, do we agree that if you take a decision that affects somebody's right, it's either judicial or quasi-judicial?
No, but every day, hold on.
My question is, what would regulations that within this context be? How would they look like? The regulation want to be reasonable, fair, and candid.
Absolutely.
Perfect.
Okay.
So you make
those standards already exist. No,
that is why the word is fair, candid.
Yes,
listen,
and I'm saying that
you have to break it down. No, listen.
No, but the decision has to suspend.
Senior Martin,
I don't know how.
Let's not mix them. A quick rebuttal. Senior, if you look at Awuni NYA, the contention was Article 23. In the sense that Article 23 imposes, and he carefully used the word administrative bodies. And now introduces the concept of fairness. And so if you look at Sofa Akufo's reasoning in Awuni and Wayek, he says, when we say administrative bodies should be fair, it requires, for instance, where there is a duty to hear the person, you hear the person. Do you get it? So that at least there is an input before the decision is taken. That in and of itself does not make me
that's what I want to understand. Whether on the decision to suspend, we'll then have a hearing of the Chief Justice. So we have to hear her first.
How?
There's a way if you want to do it.
Yeah, but because I don't see that practice anymore.
You hear the response. The response is a hearing.
Yes, the response for the prima facie.
Yes. So you looked at it.
Yeah, it's been
but the suspension is divorce.
But let's talk about something else. I think that the problem of
let's not shout. Let's slow down. Let's stop one. I'm telling you that what the Chief Justice gave to Mama, President Mama, is a response. So he, by reading through, it's a form of a hearing. We have affidavit hearing. We hear on the affidavit. So he's taking a decision based on what he's read. If you want to tweak to make sure that the exercise of the discretion is this irregular, we can do it. I'm telling you.
I don't know any comparative constitutional example. No, the reason why I'm saying this is that, listen, on the Constitutional Review Commission, I was in charge of the judiciary brief. On this very question, I don't have any example that says that beyond the requirement of hearing, how do you do it?
So it can be done.
So there's no example anywhere.
No example anywhere. So can't we do it? Can't we do it ourselves?
I'm asking that practically. So practically how? You can say that, okay, before you make a suspension decision, hear the Chief Justice again. To what point? Whether or not I should be suspended. Okay, we've given you a hearing.
Now, so let me show you what it means is that
let's round up on this.
So just one sentence. So what it means is that when you get the response, what we're going to do is circumscribe the discretion. When you get the response, if it borders on this, yes, go ahead with a suspension. If it's that, no, we can do it.
No, but whatever the case may be, even in that instance, you cannot list everything that comes out of the sun.
Maybe I'll just I beg you. Let me just find out from my learned senior. Would you draw a distinction between a quasi-judicial function, quasi-judicial function, and a presidential duty?
Yes, they are different.
Perfect.
So
Article 146. Hold on.
Quasi-judicial. Trust me.
Let's go.
That one,
who else can perform that function?
There's a reason why.
So he's coming to perform a quasi-judicial function.
That's fine.
As for the process right now, that's the law. We can't do anything, but let's not make it look like.
Well, to the extent that Oliver, you make the point. There's no reference to precedents Martin Kwegu says we can do something.
Because the law is clear that thing is quasi-judicial. Anybody who tells you that it's administrative is misleading.
Two positions that can never converge. So let's just hold on to that. It is what is existing now is what we are working with now. Okay, that settles the matter. A number of messages that have come through, also bothering on some of the questions that have been asked already about this one from lawyer Kusib Boateng says the president in exercising discretion in Motie 3 didn't affect anyone's negatively. In this case, it's been affected.
If the Chief Justice complained, so, in direct response,
yes,
the Chief Justice, as we speak, has not said her rights have been affected. So where from this legal proposition?
Well, so you...
it's basic. Oh, Regent Baldwin, anything you do to affect anybody's right.
You are not getting... But the president gave her the right to be heard.
No, it's a removal of...
Thank you.
Suspension hasn't been removed, Senior.
No, we have heard that international best practice recommend mandatory suspension.
Thank you very much.
So...
Professor Stephen Kwegu, good morning. It says suspension under Article 146 is not adjudicatory.
Absolutely.
It is a precautionary administrative measure.
No, it's not.
Much like the routine interdiction of public offices.
Absolutely.
Meant to preserve institutional integrity
and
pending...
In fact, in the Vigilante matter, President Mahama said he wants to protect the integrity of the
meant to preserve institutional integrity pending investigation. It carries no finding of guilt and does not by itself trigger disqualification. Professor Kwegu, thank you very much for the message. This one here also from lawyer Kakre, someone says, unfortunately, we tend to over-legalize public discussions, especially when meant for the understanding of many. And that is one thing that I commend this platform for, that you break down the legal issues to the understanding of the ordinary man. This is coming from a lawyer, so you can understand. It says, in this country, a president without any prior notice fell down dead. The world didn't come to an end. Ghana did not collapse. What is special, it says, about a Chief Justice, that when she is particular and no more Chief Justice, this country would grind to a halt. It goes on and on. This one here says, good morning. May I suggest that the Chief Justice must be voted for by judges from High Court upwards. From among the Supreme Court justices, the President is voted for by the state, Speaker by parliamentarians. So why not the CJ? You say, and these are the kinds of conversations that the Constitutional Review Committee, as Professor Kwesi Prempeh is leading, would be entertaining going forward. Well, in that sense. But there was another demand by the Bar Association for the publication of the prima facie against the Chief Justice, consistent with the established precedent. Professor Kwesi Prempeh made that demand that it should be published after the fact. But this one, they say there's established precedent.
I disagree.
Do you agree or support this call by the Ghana Bar Association?
We should never publish.
No, let me find out for people and then to you.
Okay, so I support that we publish after
the fact.
Yeah, initially I wanted the prima facie now, but we've got the Ghana Bar Association that once beaten, twice shy. So let's wait and publish after. But as for publication after, it's not negotiable. Yeah. It must come out for us to read. Charlotte says, it came out. Yeah, we got it. The bridges.
No, that's the grounds. No, the grounds are different.
No, we got. Oh, the report came out.
Which report? The president never issued. Not even.
There's no public report.
There's no public record.
There's no public report.
So you support after the fact?
Yes, after the fact.
To be published?
Yes.
No, the danger for me, the danger is that if you have a situation where you publish, there are reputational issues. And so I believe that some of these things, there is a wisdom in why in the superior wisdom of the framers of the Constitution, they wanted in-camera proceedings. Because they anticipate a situation where a superior court judge or a constitutional independent body may come out with no findings. But the president's reputation would have been gone by then.
Yeah.
So I strongly believe that let's keep it that as things are now.
I struggle with that. Yes, I struggle with that. I mean, I think that one of the process why people have taken the view that the president is self-interested in the removal of Chief Justice is our tendency to want to obscure everything from the public. This idea, first of all, the Constitution says that the part that is supposed to be in camera is the trial itself.
Yes.
That view then has been extended to a point where we are saying that even if a petition has been brought, nobody should hear anything that the petition even exists. All the people will wake up to is that the Chief Justice has been removed. I don't think it strengthens public confidence in our institutions that the people's Chief Justice will only hear that the Chief Justice has been removed, or now that the Chief Justice has been suspended by the President, without even first knowing that the petition existed in the first place. So we have to be able to balance this. If our concern is that releasing it in the public can compromise the process, then after everything is done, we publish it. And the people are aware of the grounds for which the person, their Chief Justice or their Supreme Court judges were removed after. If there's no prima facie case found against the person, we publish it nonetheless. So that we see that the person was then put through a process and cleared.
Yes.
Now the president that they're talking about, they're only referring to the dismissal of Kwaku Asai's petition, Professor Asari's petition by the former president, that the reasons why he said there was no prima facie case was then released. In that case, you can even say it was after the process, because his decision that there was no prima facie case terminated the process. And so when he released that, then that's it. But it was never released in Charlotte Osei. There was no formal public record of not only the prima facie decision, but also the committee's work. Yes. None of those were made public.
In fact, it was their recommendations. So even to the president. And the president's statement removing Charlotte Osei, also upon the recommendation of ABC, this decision has been taken. That is it.
Well, the third matter also directly linked to the justice system is the nomination of these 7 justices of the Court of Appeal by the president to be considered to the apex court. And we're talking about Justice Sir Dennis Dominic Ejay, currently a judge of the Court of Appeal, appointed in July 2010. Also a judge of the African Court, having been elected to the court in July 2022 for a 6-year term. He's one of the 9 members of the Advisory Committee of the International Criminal Court, and his profile is quite rich and out to be seen. Justice Gail Simon Sobere also is a judge at the Court of Appeal, appointed in Appeal on Ghana Judicial Council. Before his appointment to the Court of Appeal, he was a supervising High Court judge in the Eastern Region, also known for his mastery of constitutional and administrative law. Then Justice Senyor Jamefe, appointed to the Court of Appeal in 2010, served as a justice of the High Court before his promotion to the Court of Appeal, elected president of the Association of Magistrates and Judges, having been elected to the position in 2018, known for his work in commercial and civil litigation. Justice Kweku Teria Akabuafo, appointed to the Court of Appeal in 2022, after serving as a High Court judge for a number of years. He was one of the justices who presided over the Republic versus Atoforsen and 2 others. This was a case, Tamaklo, you were counsel. And others on the ambulance case. And then also Justice Philip Bright Mensah. He is a justice of the Court of Appeal, appointed to the Court of Appeal in 2019, having served on the High Court for several years as well. Also one of the Court of Appeal judges in the ambulance trial, which also led to the acquittal and discharge of Dr. Kasiel Atoforsen. And Justice Janapari Battels Kujo, also known as one of 2 women nominated by the president. She's currently a justice of the Court of Appeal. She was appointed to the court in 2019 by the then president, Nana Addo Dankwa Akufo-Addo, and she also has rich legal history as well, and her contribution to the legal jurisprudence. Justice Hafisata Amele Boba, also the second woman nominated in this 7. Like all other nominees, she's a Court of Appeal judge appointed in 2022 to the Court of Appeal. Before her tenure on the Court of Appeal, she served as a High Court judge where she was involved in several high-profile cases, including serving on the 3-member panel presided over by the famous co-plot case. That is your case.
No. I think that's
No, so that's his case.
That's his case.
He defended the coup.
So
the kitchen spoons and
this nomination, and then also the persons that have been named in there. A good call, one you agree with, and how it also impacts on the justice delivery system, and especially the conversation about the number of justices at the Supreme Court and the upper limit that we are hitting now.
Okay, so Mr. Galamsey, you know, we rolled back maybe at least like 7 months ago, right? Or more, but at least not less than 7, because this is the 5th month we started. You know, when Chief Justice Tokonu wrote to President Kufuor and the letter leaked, this debate, we had this debate. So everything I said at that time, I stand by that. So now let's recap. There won't be enough time to recap everything. I still don't have my time. So number 1, what happened at the time was that at that time, you know, 2 justices were yet to retire, right? And President Kufuor wanted to fill in those vacancies, even when those people hadn't retired. And then the Justice Tokonu letter came with 5 more. So I think, at that time, Professor Pong and then Justice Benasco had been nominated already, seeking to fill in Akayenzu and Mariama Owusu, who had not yet retired, right? Then Chief Justice Tokonu brought her letter for additional 5, right? That was the context. Now, at that time, what we said was that, look, the convention, and as even recognized by the Supreme Court in the case of the GBA versus Attorney General, just briefly, that's the case in which, you even mentioned it earlier on, the case in which when President Mahama appointed Justice Puama and Apau, the GBA were not happy. They went to court that they expected that the press, not just expected, the law is that their reading of the Constitution, the president should have gone strictly by the order in which the Judicial Council had ranked the candidates, blah, 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 right? So, but that's not the argument I'm talking about now. Right now, I'm talking about the fact that in that case, the Supreme Court recognized the convention. So my point is about the recognition of the convention that you have 14 justices. Some say even including the Chief Justice. Others said no, the 14 you find in the GBA versus Attorney General case. The 14 refers to the rest of the justices. It doesn't include the Chief Justice, right? So whether you say 14 or 15, my point is that that convention will recognize it. When President Kufuor was in office and then the number went beyond the 14, when we presented our report, the African peer review mechanism, were chastised for it. It was a big matter, so there was a debate here in Ghana where Kufuor was chastised that he had broken the convention, etc. Kufuor leaves office, Atta Mills comes, then JM comes, and then there's a Supreme Court matter. The Supreme Court recognizes the convention. So based on it, the argument was that if you want to break the 14, or call it breaking the 15, let's have a conversation around it, a public one, and especially let lay people weigh in. Let them come and express their opinions. And I like to quote Samson Ladi did an interview with H. Kwesi Prempeh, the chairman of the Constitution Review Commission, where H. Kwesi Prempeh went into the writings of Adam Smith, the famous economist. He also had opinions on social justice and the justice delivery system, where he said that there can't be progress if, you know, the justice system doesn't promote commerce and manufacturing. Long story short, that statement has been interpreted to mean that those in manufacturing and commerce, should also have an opinion on the justice delivery system. That's the argument. Those in manufacturing and commerce should also have an opinion. So meaning, let lay people also weigh in. If you are going to break a conversation, so I remember at the time, the statement I forcefully made at this same panel was that, or not the panel here, on this program, was that we couldn't leave the conversation to President Kufuor and Chief Justice Tokonu alone. And then it happened that after saying so, so many people also joined in and said, yes, we can't leave it to those two people. And also President Mahama is on record to have also said, yes, when he comes, he will leave it to the people to decide. Leave it to the people to decide. You can let your producer pull it out.
Yeah, I think
President Mahama said this matter of breaking the convention, he agrees that leave it to the people to decide. So this list of 7 is a surprise.
The decision of leaving it to the people is whether to reduce, maintain, or increase the numbers.
Yes.
I think that's the context in which it...
Exactly. Leave it to the people to decide. So if you also come and you want to break the convention, then let the people weigh in. Remember, we all want an efficient justice system. So you see, the comparison, as I said, there's not enough time. We can't advance all the arguments. So for now, you know, we'll go to, so please, for those who say US, they have only 9 justices, etc. It doesn't apply because there in each state, they have a Supreme Court. So each of the states, 50 states, and then DC, each state has a Supreme Court, right? So we can't compare to the Ghanaian situation. Bottom line is that we want an efficient Supreme Court, etc. We have cases that have been pending years. We are feeling it. But we've agreed that as a society, to carry the people along, let's have a national debate. Then at the end of it, we break the 50.
So you're opposed to it because of the nomination because we haven't had a national conversation on the matter? Because this is a convention that's going to be broken?
Yes, so not the total nomination, but the nomination is going to 7. So if no, you know, since then, as I said, 2 justices have retired, and I'm aware some 2 are about to. So if for any one of them that's less than 6 months, or even 8 months, or even a year, I agree we can start the replacement process. So it's a number 7 that is causing the problem. Out of that list, you know, there are 3 that as a society we all agree generally they've been hard done by the previous administration. So number 1, the class prefect, or you call him the SRC president, that's Justice Senyo Jamefe, right? He's a president of the Court of Appeal, NDG, right? Yes. To the president, far senior to some people who were appointed to the Supreme Court, right? Then Justice Dennis J, the scholar, everybody feels that this because he's written extensively, and he's been on the Supreme Court since 2010.
Yes, the
Court of Appeal. He also qualified. Then Justice Sorebare, right? These 3, their matter has been well beaten in the public domain. So it looks like at least they are the constant 3. Then the rest we can go into there. I know Justice Bright Mensah is also quite senior. But the rest of I'm hearing memories that the rest of the justices on the Court of Appeal are also not happy because they are raising issues of seniority. That there are far more seniors on the Court of Appeal than some of those people on this list. And that is an argument that was made when the other list came out. People who were senior to those on the other list raised issues. That's the time, that's the time we're saying that, but Dennis J has been there since 2010. Senyo Jamefe has been there since this. Now you see the chicken have come home to roost. Or if you like the other version, the roosters have come home to roost. So some senior justices on the Court of Appeal are also raising hell. That but a few months ago, you guys were here busy talking that Senyo Jamefe is senior. He's been sidelined, hard done by Dennis J. Sorebare. Now, in this current list, there are junior people. So that's the thing. So let's go for the public debate. And then we'll reach a certain consensus, and then we move forward.
Well,
that's it. And let me quickly add. Just one second. You remember also a few months ago when I mentioned, you know, Bafubodi, when Akufo-Addo came and told Bafubodi to resign. I want to see Akufo-Addo's face today. The man he orchestrated asked him to resign at all costs, and sending Godfrey Dami to Bafubodi all the time. Now he's CJ. He's CJ, acting CJ, you see it? You get power, you think the whole world belongs to you. Bafubodi should go. Bafubodi should go just because he voted against Akufo-Addo in the election 2012 petition. Now he's acting CJ.
Well,
You see, and I'll come to you on this, because
you see,
reference is made to that 16-page letter that the now suspended CJ wrote, justifying the 5 that she proposed to the president, to the then president, to consider. Reason why they needed this number of justices at the Supreme Court. Is that argument valid in this case as well?
There's a news item that I found online. Would you permit me to read
in brief
the headline? And it's a news item dated 8th July 2024. Appointment of more Supreme Court judges will ensure effective justice delivery. Godfrey Adame. I want to believe that the reason there is still valid today. I just want to believe so. But you see, unlike the United States of America, you see, the U.S. Constitution does not say that there's the need for only 9 justices. The U.S. Supreme Court doesn't say that. However, they have evolved a convention that have allowed the process to remain what it is. President Mahama had the benefit of becoming president before. And for the 4 years that he became president, he appointed only 2 Supreme Court judges. Professor Samuel started the process with the appointment of, I think, Justice Badegbe and Co. I think the process didn't end, and President Mahama came. But in terms of he being president, he appointed only 2, His Lordship Justice Yao Apel, and then my Lord Justice Gabriel Poaman.
Yes.
These 2. This time round, the president has put out there the nomination of 7, with a view that the workload argument that has been made relative to the Supreme Court judges, the 7 that are coming, and always know that the nomination does not mean automatic, like it's automatic, because you need to go for parliamentary approval, blah, blah, blah. But at this point, in the wisdom of the president, these 7 on the court would complement. The argument has been made that our Supreme Court, unlike that of the U.S., has too many jurisdictions. And that compounds the work for the Supreme Court judges. In Ghana, our Supreme Court has a jurisdiction even to entertain appeal from the National House of Chiefs. Our Supreme Court has a review jurisdiction. Our Supreme Court has a jurisdiction that allows it to make a determination as to whether a document or information has national security implication. My brother here has been litigating that matter with the then National Security Minister, Kandapa. So, aside its original jurisdiction in Article 2, it has many other jurisdictions. And the position is that this actually compounds the work of the judges. Incidentally, you notice that Supreme Court judges that we have now, it is either 62, 63, 64, 67, and others. Imagine the workload. And so the idea is to bring these 7 to augment relative to the workload. I mean, it's legitimate. I will not begrudge my senior here if he expresses a certain view. I mean, that's what makes our democracy what it is. What I found extremely worrying, and I'll say this. Yes. Currently, we have 48 justices of the Court of Appeal. 48. Please check the number. 48 justices of the Court of Appeal. Only 4 were appointed by President Mahama. 44 appointed by Akufo-Addo in 8 years. 44 justices of the Court of Appeal in 8 years.
I think we have the records of that. We'll put it on the screen as you
Perfect.
Yes.
As we speak, from 2017 to now, Akufo-Addo had appointed in excess of 15 Supreme Court judges, some now on retirement. my Lord Ashikote, my Lord Nene Amegache,
I think he said 18, 19.
Yes, in 8 years. He's done in excess of 15 Supreme Court judges.
Kayezu, Mariama.
All of them.
Papa Kayesu is also on retirement.
Yes, now. So that's in excess of 15 in 8 years. Now, if you look at the High Court, it's over 113. 113, over 100 High Court judges in 8 years. He's the president. He has the power to do, and that's what he has done. President Mahama is exercising the full benefit of his powers as president on the basis of need assessment. And so where there's a need, he will fill in the gap. What I just want to say on this matter of appointment is that over the week, the minority had a press conference addressed by the Honorable Afenyo Makin. And he made the point that the reason why President Mahama has nominated these 7 Supreme Court judges, if approved by the Parliament, is that he wants a 3rd term.
Very ridiculous.
My learned senior Afenyo Makin, what is happening? Senior?
Disinformation is deliberate.
I mean, deliberate. Deliberate. Is it misinformation or disinformation?
Disinformation.
Disinformation. Okay. Look, why would a member of Parliament deliberately court public disaffection for a president who is sometimes called his friend, right? On the basis of deliberate, I call it misinformation. Because one, President Mahama has already publicly said that he has a farm in Savannah region that he can't wait to go on retirement and go to his farm. President Mahama had made it clear that uniquely God has been so merciful to him. Look, in fact, today in Ghana, in the next 100 years, only 25 people can become president. That is even if they are doing 4 years, 4 years, 4 years. Out of 32 million. God has been so kind to him to even think of tinkering with the Constitution. In any case, assuming, even for the sake of argument, that there is even an attempt to amend the Constitution for a 3rd term, assuming without admitting, what has the Supreme Court judges got to do with the amendment of the Constitution? Because that provision is very, very entrenched. The one that puts term limits is entrenched.
So there has to be a memorandum.
Referendum. Afenyo Makin knows this. He knows that even the threshold to amend that provision would require some MPP members must vote. Because that is a very strong threshold. He knows that the Supreme Court has no say. So if you recall, the initial argument was that this removal of Chief Justice process is because President Mahama wants to extend his tenure. What has the Chief Justice or Supreme Court judges got to do with attempt to amend the Constitution as it were to lift the term limit? So this deliberate, mischievous attempt by Afenyo Makin to court public disaffection for the person of the president, I have always said, as an appointee of the president, I pledge that I prefer to go down for the president to go up. And the reason is simple. Yes, ultimately, responsibility lies with him. President Mahama has demonstrated greater fidelity to the laws of this country. He has shown that he will not do the impossible by attempting an amendment of the Constitution.
Yeah, that one.
Never. And his patient doesn't even allow him. Do you know that he had intervened in other African countries where presidents have attempted to change the,
that place, he scores greater than his predecessor.
Yes. Yeah. Look, even Akufo-Addo didn't amend the constitution for a term when you are talking about President Mahama. Let me see.
Let me bring on this particular one, because if you look at that 16-page that position by a leadership Justice Geto Tukono, she makes the point clearly and strongly that, in her view, the reasons for the number of 20 justices for the Supreme Court will enable the setting of stand-alone panels of 5 and 7 or 9 judges to work on any set of cases on a given day, depending on the jurisdiction of the court being exercised in any given week, thereby reducing the specter of constantly reconstituted panels during days and sittings. That position so valid in this instance, quickly?
The position is very valid. I have attended, that was just last 2 weeks, I was at the International Conference of Women Judges in Cape Town, and I listened to the judges talking about judicial well-being and how a judge can be traumatized because of caseload and all of that. So that is something the judges are talking about. So that's not a problem. The problem, if you heard my senior Eduje, he said that there are 44 judges at the Court of Appeal. Out of that, 44 are appointed by, he said, Akufo-Addo. So you see, the problem is the role of the executive in the appointment process. Because in Ghana, according to the current constitutional framework, the executive plays a central role in the appointment of justices. Then it becomes politicized, so that a judge is mentioned, and then a particular president is mentioned as the one who appointed the judge, and that they appointed 44. Okay, we appointed only 4. So that is the problem. Let's go back to the rudiments. What are the qualities of the judiciary? The judiciary at all times exhibit 4 qualities: independence, impartiality, honesty, and competence. So every appointment process must be geared towards ensuring that we get people who possess these qualities. And while the executive must play a role in the appointment process, that should be at the very last step. If you have an independent appointment committee where vacancies are advertised, where the process is open, and people can, everybody, based on equality of opportunity and merit, anybody can go in and apply and go through the process. At the end of the day, a recommendation is made to the president to appoint, and the president must comply with the recommendation, or where he thinks he deviates, he must provide reasons for his departure. If we have this kind of system, we will not have the problem of, okay, other than that, these 7 individuals, as you look at them, may well all be qualified. And then there may be genuine need to increase the number so as to ensure that the well-being of the justices is also preserved. But because the president plays a central role in the appointment, the opponent may see it that they want to also bring in their judges. So now, if we don't take care, judges are now being appointed, though it may be on merit, but because of the nature of the fact that the executive plays a central role in the process, then it becomes a partisan process. That should be the concern. The number 7 should not be a problem. Should we increase the number? That should not be a problem at all. It is because the executive is playing a role, that is why the opponents think that is not a good thing. But given the chance, the opponent may also want to also appoint some. So we must, while this is happening at a time that we are looking at the constitutional review process, we must look at the appointment system. We must limit the role of the executive in the appointment. They should play a role, but that role should only be played at the end of the day when a recommendation is made by an independent appointment committee.
So you see, the position of Olamide Kpebo is that, to the extent that there hasn't been a national conversation on this matter, he's opposed to this proposal and the nomination by the president of these beyond the convention of the 15 that we've been used to for some time now.
You know, I think that, you know, ideas about constitutional conventions with respect to the size of the Supreme Court are useful. But a more holistic conversation we need to be having about the Supreme Court is this workload. And in the Constitutional Review Commission process, we had looked at this in many ways. Our first instinct was that all interlocutory appeals should terminate at the Court of Appeal. We have an example of this. When you take under Article 99, I think, with respect to parliamentary elections, we've decided that all appeals end at the Court of Appeal. And so there has to be strategic ways in which we think about the workload of the Supreme Court more generally. I, for instance, propose that there's no reason why the Supreme Court should be the sole and exclusive constitutional court. In the U.S., every court has the jurisdiction to consider constitutional matters. So that any judge I appear before can make a constitutional decision. And if I disagree with it, I go through the appellate process. Perhaps we limit the original jurisdiction of the Supreme Court to only presidential elections. And everything then it becomes an appellate court. We have to then seriously think about the ways in which we can be able to reduce the cost workload. If not, the arguments around this will continue to increase. We are a country that under-litigates. We are a country where so many parts of the country are underserved by lawyers. The more lawyers increase, the more people then have the means to be able to access the courts, the more the workload of the courts would increase. So we have to be intentional. Every other court can increase, right? Like we have several high courts which are being expanded. The size of the Court of Appeal is ballooning. I mean, 48 is incredible. It was never at any point where we have gotten there before. So obviously we can't be that, okay, even though the Supreme Court's workload is increasing, we want for some reason to maintain that without addressing the pipeline problem. So that pipeline, I think, is what we have to focus attention to and be able to address for a more holistic conversation. I mean, 15, 14 sounds nice and roundy, but if we don't address why the need and the demand for them to increase, we'll always have this problem. I have said more generally, and in terms of the richness of judicial jurisprudence, the reason why we have so many unanimous decisions is because of an overworked court. Because the judges then decide, let's go to conference, quickly decide, okay, okay, you go and write it, we all agree. Because it's too much work for every day for the judges.
I disagree with that.
Let's be fair. There's a practical reason around this. There's a practical reason. Not in the strong political
you see, I have always commented, if you look at the old Supreme Court cases, you see each judge put up a view.
Right.
Subsequent ones, you can see, oh, I've had the benefit of reading beforehand, and I have nothing useful to add. It's also because of reasoning. If I find your reasoning to be okay, why not?
But you see, the overworking is a big problem. At this point, for instance, I was clerk at the International Court of Justice. In almost every decision, there's a majority decision, there's a dissent, and there are individual opinions. For almost every judge.
And concurring.
Whether you concur, you must say something. Because everybody is seeing it as an opportunity to shine and elevate their own view.
It's even an accountability mechanism.
You can't do this.
You want to know what you are saying.
You can't do this if within the term of the Supreme Court, there are 60 cases that the court must deal with. And they don't have clerks. Who are working with
So 300.
So you can't. They don't have clerks who are helping them with research and things like that. It is impractical. So for me, I think that the more holistic conversation is that there are too many cases that this original jurisdiction is too wide. Let us diffuse some of them, and let us also limit some cases that should go to the Supreme Court, particularly interlocutory matters. Let the Court of Appeal exercise supervisory jurisdiction over high courts. We don't have to be going to the Supreme Court for certiorari. Let us go to the Court of Appeal for certiorari to quash offending decisions. So there's so many tricks and ways in which we can reform this. And I think that's one of the things that is before the Constitutional Review Committee, for them to look at the ways in which we limit workload at the appellate court.
Right.
That would be my view on that.
Thank you. It's live here on Key Point, also on 3FM 92.7, TV3 Ghana on Facebook, Voice of London Radio in the heart of the city of London. And so we're going to go for a quick break. I have a number of your messages. I am clothed this morning by Kogra Clothing. It's the best version of you with this outfit and many others that you see me wear on Saturday here on Key Point. You can locate Kogra Clothing on the Spintex Road, 18 Junction, opposite the Allied Oil Filling Station, ground floor, same building with the Ghana Made store. Call them on this number, 0244 238 341 for this outfit and any others you've seen me wear. 0244 238 341. Cobra Clothing is the best version of you. We're back shortly after this quick break. Stay with us. Welcome back. This is Key Point on TV3. We're live on 3FM 92.7, also on TV3 Ghana on Facebook and on DSTV channel 279. We are all across the world on 3news.com. I acknowledge the 4,373 of your messages. Thank you very much. And yes, I may not be able to read all of it, but I thank you very much for the messages. Talk with Dr. Nyaho Tamaklo, good morning, and thank you very much. In fact, on Sunday, he is on Hot Issues with Kemini, and that book that he's written as well. Kojo Chumbuafo says, okay, he says, we the mortal beings are learning a lot this morning from the legal display of knowledge. I hope that we are all carried along every step of the way. It says it's been interesting watching.
This morning,
Thank you.
The engineers are listening to the lawyers.
So this one here says that 47 voted for, 5 against, and a significant number abstained. This is an inconclusive statement from Xavier Koji. You say, thank you.
And we are over 5,000 though. More than 5,000 lawyers.
So this one here, my question is, the Bar Association is being manipulated? And if they form the quorum with 47, how many members are they? And how does the quorum form? I think that's an explanation that you gave at some point. This one here says, I agree with the call for an emergency reconstitution of the Bar Association to have a meeting on this matter. And thank you very much for your message. This one here says, it's great conversation. A number of you calling for the repeat of the program, which I tell you that management has taken that into advisement, and so we will definitely do that. But I on this note, want to say thank you to the National Commission for Civic Education, NCC. They gave us some 50 copies of the Constitution to share. And so a number of our viewers who came in first come, first serve, got the copies of the Constitution. And yeah, let's just show that. Thank you to the NCC.
I'm addicted to Key Point. Key Point has been my breakfast since. And so anytime the show is going on and I am not part of it, I feel like something is missing.
I normally watch the program, and anytime you are watching, they will just quote something from the Constitution that you don't know what they are talking about. And it's good for us to have it. If everybody have it and knows what is going on, if the wrong thing is being done, you may have it and then correct the person. Not only the elderly, the children, everybody must know what is happening and what is in this Constitution so that we'll work according to it, and then Ghana will be peaceful.
I've been sent by my dad to come for one of the Constitutional Book of Ghana. And I'll also be reading it because I also want to know all the constitutional rules in Ghana. And I've been also watching the Key Points on TV3. And thank you very much for that.
The free copies of the Constitution shared to some of our viewers, because today it's been all constitutional law. They follow every step of the way, looking into the Constitution, the provisions that you've been quoting as well.
Yeah. Okay, that's good. That's laudable. Let me mention this. So from the NCC here, you know how democracy works. Somebody sent me a message that by the NCC, their own staff, they've not given them copies. So please, NCC, this is a charge on you. Somebody sent me a message that even your own staff, you've not given them copies.
Let's say thank you to them.
The Good Samaritan. So, you know the Lotto doctor. The Lotto doctor.
Let me add this one more. It's on the occasion of your birthday, right? That's why they gave the gift. Yes. But we haven't had a party, number one. And then lawyer Dr. Edward Adodankwa, his mom's birthday is today, 70th birthday. Madam Agnes Menu. So let's wish Madam Agnes Menu a happy 70th birthday. Dr. Adodankwa listens to your program.
Thank you so much.
Religiously.
Thank you.
Let me say that I've been across the country doing a lot of constitutional education stuff. The vast majority of citizens of this country have never even seen the Constitution before. And so it's a commendable thing, ensuring that people can even hold the Constitution. This country is built on the basis of that Constitution, and I think that is a duty that we must ensure, whether through our school systems or anywhere, that every Ghanaian must have access to the Constitution as we do the Bible or the Quran. So I commend the NCC for this, and I do hope that the Republic now, which is in the safe hands of people like my good friend Eduji, would ensure that it becomes part of, so that you're not accused of only the free part, that we're also giving free constitution to every Ghanaian that lives in this country. And everybody will have their own copy.
And you see, with this said, I strongly believe that is the more reason why we need to empower the NCCE, because it's one of their core mandates. You see, when people are informed, their contribution towards the, relative to the democratic conversation becomes better.
Indeed.
You can't keep people in the dark and expect meaningful contributions from them. And so the decision to give the
copies
small,
of the Constitution,
to the abridged version of the Constitution, more or less, to our people is commendable.
And there's one that we intend to collaborate with the NCCE on subsequently, even beyond just my birthday and the gift giving. But Professor Bafo Agyemang-Duah, just a quick one on this particular conversation before we went on the break on the nomination of these 7 Court of Appeal justices to the Supreme Court by the President. Just a brief one.
Yes, I think ordinarily this shouldn't be an issue at all, especially because prior to the elections, we know that the Chief Justice had requested for additional justices, and she gave reasons that I believe are still valid today. But I think there's one thing we should also note. It seems to me that the pre-election statements of intent of candidates tend to muddy the waters for post-election decisions that they may wish to take. And why am I saying this? You see, if you go back and look at the way Madam Charlotte Osei was removed, prior to the elections and the victory of the NPP, the party had declared that once they win, they will remove her. Okay? So once that decision was made, naturally, the opposition will see that as fulfilling their predetermined plan. In the same way, we also know that prior to the elections, the NDC made statements about balancing the judiciary. All right? And so, once they are in power and they are taking that action, people are believing that perhaps it was because of that statement. So I think our political leaders must be a bit cautious about these things, especially relating to some critical constitutional matters as we are facing today. Other than that, I don't see any problem at all with the decision to raise, because the case had already been made by the Chief Justice. Also, suggestion has been made in terms of the numbers, even though I think it's reasonable. The fact is that we cannot continue to expand the Supreme Court based on increasing workload of the justices. So the idea, as proposed earlier by one of the panelists, that, look, why don't we reconsider the jurisdiction of the Supreme Court, making sure that not all these cases have to come as high as the Supreme Court. If we do that intelligently, I'm sure the workload can be managed, because I'm afraid that if we have to continuously expand it because of the demands of the work on them, then I don't know, at one point we're going to have 50 or so justices. And the financial cost of expanding should also be noted. As we are seeking to have a lean gap, I think all sectors of governance should be affected by that principle, so that we don't continuously just expand. I think that's what I would say. But I think it's important that politicians, at times, they cause these problems for the public. Why these pre-election predictions, intentions? So for me, that is my biggest challenge here. And I think, if, for instance, Afeni Markin is saying the president is making this decision because he wants to extend his tenure. I mean, And I agree with lawyer Tamaklo. I mean, John Mahama would be the last person to do that. Okay, but you see, when I think the NDC was in power, they raised the same issues about Akufo-Addo wanting to extend his tenure, if you recall, only because he had made some appointments to the Supreme Court. So I think these are matters that I think our politicians should be a little bit more responsible in terms of such public declarations, so that once they are in power, decisions they make will not be seen by others as politically motivated. That's what I can say to that.
Thank you very much. I
support it. The workload, like we've all said, and there's a unanimous, we are all in unison with it, that the workload. I mean, I was at the Supreme Court sometime 2020 when I filed to have attempted suicide struck off our criminal books. And you see, I witnessed that firsthand. The workload, sometimes you see the impressions on the judges. Other times too, it weighs on their health. So the panel would come, and then the presiding, the president would say, sorry, this person is not well. And the matter dragged for almost about 4 years until Parliament. So when they were ready to hear the matter and take the necessary judicial decision, through Parliament had to, at the time, had to pass the bill for assent for the matter to be struck off. You know, so that in first hand showed that, and that's how I witnessed it, that they overburdened with decision. Right. If you go to South Africa, for instance, the Supreme Court is divided into two. So they have the Supreme Court of Appeal, and that has 23 judges, and then the Constitutional, that has 11. So you put it together, you have 36. So it makes the work less stressful, and definitely you would have a lot of judicial contributions coming from the judges, especially given their ages. So I mean, it's well to do.
Right. All right. Thank you. And that leads us to the next in the final issue, which lawyer Digital Maklo and just lawyer Oliver Bakabomawo on this matter that the president cited in his midday speech about the fight against Galamsey being a complex one. He underscores why this is the case. And this is what the president said. Take a look.
Galamsey is a complex one. And when I was vying for the presidency, I did not kid myself that when I come into office, I will win that fight in 4 months. Yet, we will not give up. Our gallant men of the armed forces and security services are up to the fight and will continue to score successes against the selfish companies and individuals who are destroying our forests and polluting our water bodies. As far as the fight against Galamsey is concerned, I say, aluta continua.
That's the president just underscoring the situation as he's confronted with right now. And what's really the point of issue with you, Oliver Bakabomawo, really? Because there's been that call for this administration to fight this head on. What are they not doing?
You know, I mean, I don't think anybody can discount the complexity of what we need to do in terms of what Galamsey is. But complex problems also require complex and comprehensive solutions. So far, the plans and the ways in which we're going about this has not been revealed in any strategic policy document for us to understand how does everything fit in. There's been a lot of ad hoc. To find out what the government is doing, we have to wait for some ad hoc press conference. So the minister for lands came out and issued did a press conference and laid some ideas down on the table. Then you had the Minister for Interior and also later the Minister for Foreign Affairs coming and talking about foreign nationals who are involved, who are going to be deported. We are asking for a comprehensive policy strategy document that will show us that there's the part about stopping people from going and pulling down the forests. There's the part about criminal justice for those who have been involved in this that has to be talked about more generally. There's the restorative part about the environment and reclamation, and also the need to cost all of this. There's the pipeline problem of excavators that are coming in. How are we tracking them? What are the individuals behind? Which also needs to be addressed holistically for us to be able to understand the full strategy that is going on here. That full strategy has not been unveiled in a compact and comprehensible way. There are conversations, of course, people are also calling on the government to live up to some of the pre-election promises that were made. For, of course, there's this conversation around LI 2462. Now that the acting chair of Gold Borders indicated that Parliament, once Parliament is convened, is going to be dealt with. Yes. Feeling good myself, what I've had on this is that this is something which should have been done at the get-go. Of course, I had a conversation with the Attorney General, who laid out the reasons why a decision was taken in the beginning to amend. And I understand his motivation and sentiments, but I'm saying that a lot of the conversation about this can even be done about reforming the Forest Act, for instance, where we have had the Forest Act since 1927. Yeah. It is not fit for purpose for today in terms of the environmental challenges facing our forest. I believe that the forest, even forest reserves, there has to be a complete ban on mining in forest reserves. It's not only just deferring to the pre-existing guidelines that existed that EPA did, but that we must make it such that as far as forest reserves from which we get our water, ecosystem services, we don't even mine in them at all. So for me, for somebody who's interested in these environmental conversations, I want to be able to see a holistic strategy that we can all refer to as this is the way forward for Galamsey that we are dealing with. The direction has to be clear for everybody that we can be able to measure the government's actions on. In addition to that, I think that one of the biggest challenges we're having, even in this conversation around Galamsey, is that it's almost as if there's no alignment between even what we are promising what the Gold Board is going to be doing and how we are intending to fight this is going to be doing. A lot of people within the small-scale mining sector is telling us that in the small-scale sector, 90% of gold that we have in the small-scale sector is Galamsey gold. So some of the projections that we are making confidently vis-a-vis the Gold Board and our expectations there, where are you going to get it from? Okay. How significantly are you going to be able to capacitate a cleanup within the small-scale sector to be able to put their competencies to the point where we can say that we are mining in a way that accords with environmental protection standards? It doesn't exist. Thank you. Finally, before you go, the EPA and the Mine Minerals Commission have given so many licenses that far outweigh their capacity to monitor compliance. They don't have the capacity to do this. So why is there no stop and moratorium on the licenses we are dishing out? This must stop. We must catch our breath. We must be able to put people and resources in place to make sure that for every license that we give up, we do have the resources to monitor compliance. Without that, we are recreating the problem.
Yes, yes, I mean, this is a quick one. Like my president pointed out, it's a very complex one. Complexity in terms of financing, complexity in terms of who the people are, the kind of equipment, and in fighting it. The only challenge I have with the issues raised by my learned friend Oliver is the fact that he says we should have more or less documented a certain mindset in terms of policy direction. The issue with fighting crimes and disclosures is that too much information also gives you away, because you don't want a situation where you put so much information out there in public. The more information you put out there, the greater the opportunity for the persons engaged in this illegality to come up with sophisticated means of, as it were, hiding the activity that they are engaged in. So I pray, and all of us here, to help the president and this government to bring closure to it. Look, I remember vividly in the past, organized labor, at a point where maybe we needed to declare a state of emergency, basically chickened out. Yes. For me, that was a very decisive moment and would have sent a message to all of us But just at the tail end, organized labor started giving excuses, among others. It is my hope and belief, and I know the person that President Mahama has tasked, the Honorable Ama Kufi-Boa, the Interior Minister, the Attorney General, and all the persons, the heads. In fact, I told the IGP over within the week that his men are doing excellently. The soldiers who have been deployed, they are doing so well. For me, two things matter to me. If we're able to protect our water bodies and our forest reserve. Why? It is gold mining that brought Don Diego de Azambuja to this, this beautiful country of ours. We have always engaged in mining. But it's the responsibility associated with it. That is what the challenge is. The use of champagne and others. So we can finish this once we have, or we build a coalition of the willing.
Lord Matibebo, there's a quick one on this.
Okay,
quick one.
Good. Yes.
That's final. We go.
Yeah, so what I can say is that, yes, we continue to implore the president to walk his talk. And most especially, Ghanaians are behind him because even before President Mahama took over, there had been a shift in public opinion where citizens are now very concerned, and so we push the previous government. So, even the LI 2462, they were about to repeal it, right? But they didn't have enough time. So all I can say is that right now, the most exciting thing is that citizens are saying no to Galamsey, and most especially in forest reserves. And my personal interest, well, it's also for all Ghanaians. Our Etiwa forest. You can never talk about Galamsey without talking about Etiwa forest. Akufo-Addo wanted to mine in Etiwa forest and went to court. So the shift in public opinion now saying that no mining in forest reserve is good for me. It helps my case in court. So you see that, and of course it helps all Ghanaians, because if you drink water from the Wager Dam, then that's water from Etiwa forest you are drinking.
Yes.
If you drink water from the Wager Dam, that's water from Etiwa forest you are drinking. Etiwa is the headwaters for Ayensu, Densu, and Brim rivers. Right? So please, Ghanaians, let's keep the pressure on to help the president.
5 major rivers have their source in the Etiwa forest. Simam, 1 minute.
Yes.
Quick one.
Yes, I would only advocate that the forestry guards, by legislation, if they could be brought up to services so that their fight will be more combative, rather than just taking, being wardens just for the forest. But the environmental challenge has changed its color. And it is my prayer that there should be a change in approach if they could be augmented to services where they could wield a certain limited form of ammunition, and their combative approach would also be changed so that they can have arrests and also deal with the menace. It would also engage so that the military supporting them would also show up. So that's basically my contribution.
And a quick one, I beg. Over the weekend, President Mahama launched what is now known as the Mahama Care. The issue about people with chronic, thing. I think all of us here, we should, in unison, help, increase the funding, source into that particular. And more importantly, the issue of the Jumarua program. We want
to give a 6 months salary in there.
For the Mahama Care program. All of us. Look, I always say, disease doesn't know party colors.
Right.
Let's all, in our small way, help to
support,
grow the fund.
Godwin Eduji Tamaklo is acting CEO NPA, Director of Legal for the NDC. Thank you so much. Christian Mamhesi is private legal practitioner. Thank you so much. Also, Martin Pebo is a private legal practitioner. I do appreciate your time. Thank you so much. Lawyer Saeed Salahuddin is Fund Manager, Africa Judicial Independence Fund. Thank you also for coming. And then also, Lawyer Oliver Bakavomawo is a private legal practitioner, social activist. Thank you. Appreciate you. Professor Bafwa.
He's also Godwin. He's Godwin. He's abandoned that one for Oliver.
Professor Bafwa Jimendia, thank you so much for joining us. My name is Alfred Okanse. Have a great weekend. On behalf of the rest of the team, we appreciate your company.